42. bike taxi matters. Not matters relating to bike taxi. Lord, sir, directed them to. It's an appeal arising from common order. Lord, prohibiting Lord the operation of bike taxis. And Lord has directed that the matter be listed on Friday. Can I request that a connected matter that's also been filed be listed along with that on Friday?
Which is coming on Friday?
Lord, writ appeal number 848 of 2025.
Okay.
It arises from a common order.
That also and this also.
In both.
You'll have it, but no objections?
My Lord?
Are any objections here?
No, my Lord. My Lord, the caveat, there's a caveat has been filed by the government. And
No, other than that, on the appeal.
no, my Lord. It's coming up for the first
What
time.
does your briefing counsel say?
No objections. He's saying no objections because it's been filed.
Okay, Friday.
Can I request?
1 minute, ma'am. These are only 2 appeals, no, Mr. Kumar?
There's only one appeal, my Lord. The other appeal is coming up on Friday.
The other appeal is coming?
Up on Friday. My Lord, there's an appeal filed by Uber. This is an appeal by Ola.
But why there are 2?
It arises from the common order, but different parties. My Lord, witnesses were taken together for a common order. No, I'm just giving 2 copies of the memo, my Lord. I'm sorry. Just 2 copies.
That's what I thought. We thought.
Yes.
Just give it one back.
Wait.
Just give one back. Just keep it. Yes, ma'am.
One matter relating to green bench matters.
Yes, ma'am.
But I applied for the Quarry license, my lord, for the NOC.
It's a fresh matter.
No, my lord, it's a pending matter, my lord. Now, my lord, they issued a NOC to the other persons, my lord, but rejected mine, my lord. So there is an urgency, my lord.
What have you filed?
My lord,
What are you seeking?
my lord, I'm seeking the NOC from the forest department for the license of quarrying vessels.
That's right. But are you seeking any interim directions?
Yes, my lord.
Have you filed any application?
My lord, I filed an interim prayer, my lord. Interim relief not.
It's part of the writ petition.
Yes.
So is there any date given in that?
It's yes, my lordship.
Which is the date?
In July, my lord. July.
Why don't you file an early hearing? Who is appearing for the other side?
The state, my lord.
The state is appearing.
Yes, my lord.
Memo system. But have you informed the state? Who appears, ma'am? You appear? You just take this thing. We'll have it. When do you want? We'll have it in Monday, Tuesday.
Please,
Not next Tuesday. What is the urgency? Tell us.
my lord. Now, my lord, they issued a NSC to the
But there is no prayer qua that.
my lord. My interim relief not granted, my lord. It's in pending, my lord.
You have to think over it.
Please, my lord.
If third party rights have intervened, you want to make them a party. Can there be an interim order to the prejudice of that third party? You know, all those issues need to be looked into. You're getting the point?
Yes, my lord.
That's one. Possibly, we don't mind it, but you have to, by the state, we will have it. But if you are seeking anything, stay, you look into it. You want to think over or you want us to list it?
My lord,
Just give it next week, ma'am. Yes.
Your Lordships,
much better.
here's a case of contempt of court. 2 daily wages staff were about to be terminated and an interim order was granted by the Honorable Court. And since almost 10 months, their salaries have been withheld, Your Lordship. So kindly post for an urgent.
What are these? What do you say?
After the interim order by this Honorable Court, their salaries have been held up. They are a mere of 10,000 rupees. They are daily wages, cleaning staff. Another petition before this Honorable Court. Myself, the aggrieved, my land was grabbed by the government for Hemavati Jalashaya project. Since 2008, I have not yet ever given a single rupee of compensation, Your Lordship.
What have you filed?
Um,
Is it a writ appeal or what?
It's a writ appeal, Your Lordship.
It's a writ appeal. What
Yes.
happened before the learned single judge?
I have no idea. My senior has to update it.
What is
So if you could
urgency?
post it for an urgent hearing, we can present it.
What is the urgency?
Urgency here is I have not yet availed any compensation since 2008.
Objections removed?
Objections removed. Your Lordship.
All?
All.
Just give it after 2 weeks.
Much obliged.
Yes.
Lordship, it is a public interest litigation, Lordship. The respondent has putting up illegal construction on buffer zone, Lordship.
Who is putting it?
Lordship,
Who is putting the construction?
some third parties, Lordship.
Where are you?
Near Bangar,
What is your locus?
Public interest litigation, sir. Lordship.
Just take it, let's see. Objections removed?
Objection complete, Lordship.
After 2-3 weeks. Yes, any other mentioning?
It's a press contempt petition, my lord. The direction, learned single judge has issued a direction to consider the representation by the complainant, my lord. Though a representation along with certified copies
They have not complied with the order.
not complied.
What was the order?
And to consider the complainant to the queries raised by the complainant, my lord.
What were the queries which were
That
raised?
is the some other details were sought for the personal reasons, my lord. Therefore, they have not issued any endorsement or any answer.
Take it, ma'am. Let's see.
Monday, my lord.
My
We will
lord,
give you a date,
Please.
not Monday.
my lord, it's a land acquisition matter. In WP, the matter was heard in part and final notification was set aside, my lord. And the same was remitted back to SLAO. So all the procedural aspect was followed. So we want to, we want to file this appeal on this, and that's why we want it to be posted, my lord.
What is the urgency?
My lord, due to this petition is pending, we are not able to, there is a delay in development of land, my lord. So,
No, you were the petitioner there. No, you were the respondent there.
responded, my lord.
Before the learner single judge.
Yes, my
Okay, now agree with that order of remand.
please, my lord.
What is the urgency?
There is a delay in development of land, my lord, due to which.
Just give it, take it, ma'am, after 2 weeks or so. Yes.
My lords, it's this civil contempt case. The accused has failed to comply with the orders of the single judge, wherein the single judge has passed orders to towards a payment of the gratuity amount to the complainants, my lords. Hence, the matter of the court's urgency.
Just take it, ma'am, that also.
There are 9 petitions, my lord. It may be listed all together.
What are you saying?
All are the 9 petitions are there in total. It may
9?
be 9, my lords.
But object is removed.
Please, my lords.
Just give it after 2 or 3 weeks.
Please, my lord.
Take the date.
My lord, it is for admissions. The urgency is the complainant and his family is undergoing a severe financial crisis.
What are the direction given? What was the direction given by the single judge?
It is a non-compliance of the trial court order by the
Trial court or the single judge?
from the trial court.
Is it coming? The contempt is for an order of the trial court.
Yes.
What was the order?
Go through it and then submit.
You will go through it.
Yes, sir.
2:30 you will mention it. And we want to hear from you. What was the direction? What was not is complied with. Okay. Yes, call the list, ma'am.
Serial number 1, Lodge.
Matter pertaining to serial number 1, 1.3 and 1.4, my lord. The office objection is to serve the copy. It has been served on before the last date itself, my lord.
What is that?
Acknowledgement for having served the copy to the caveator.
You are the caveator, Mr. Rajshekar?
Yes, please. Yes, please.
That's all. He's here. Why do you have memo? Now tell us what is this commercial?
As against my lords arbitration, the award passed by the arbitrator, they preferred appeal, my lords. Appeal also ended in dismissal.
We look into it.
Please.
What was the stay granted? Precipitative steps not to be taken.
That is the order passed now, my lords, restraining us
Assisting from creating third party rights.
third party interest. My lords, joint development agreement came to be entered into between my lords, the landowner and the developer in the year 2012. They were supposed to complete the my lords project within 2 years. They did not, my lords, even commence the project, resulting in my lords, I initiated the arbitration proceedings.
Yeah, we'll just set out for hearing.
Please.
Just say this, the copy of the appeal paper book has been given to Mr. Rajshekar, learner counsel appearing for the respondents in these appeals. Hence the office objection is overruled.
I have also filed my lords appeal.
There are cross appeals?
My lords,
Yes.
The arbitrator, my lords, permitted us to, my lords,
Yours is 1.1,
yes, 1.1, 1.2 and 1.5.
1.5. Just say this, in Com Appeal 2901, then 3, 1.3 and 1.4. Copies of the appeal paper book have been given to Mr. Rajshekar, and hence the office objection in these appeals are overruled. We find that a cross appeal have been filed by the other side. If that be so, we issue notice.
May I submit this, my lords? My appeals are prior to their appeal, my lords.
So,
May not be cross appeal, my lords, is my submission.
no, but in any case, they have also come
They have also come, I have also.
against the common order. That's
Oh,
why
again the common,
that's
yes.
why we are conveying.
Yes, yes.
Anybody else are there?
No, no, my lords. They are the only parties. No.
You represent all your respondents. They
Yes,
represent
they
all the
represent all.
appellants. The counsel for the parties to file their written submissions along with the judgment they intend to rely upon. Full stop. The order dated 22/5/2025 in Com Appeal number 290 of 2025 shall continue till the next date of hearing. Okay.
Grateful.
Grateful, my lord.
Well, we have overruled it.
In my appeal, my lords, it appears I have to.
In the meantime, the counsel for the appellant in 1.1, 1.2 and 1.5 shall clear the office objection.
Please. Grateful. my lords.
Obliged, my lord.
14(8). Serial number 2. Government advocate.
State appeal, my lord, will clear the objection.
I appear for 2.1. I have filed contempt petition against the state for not complying the orders of the Leonard single judge. Now
But there
the
are 9
state,
objections.
We will clear it during the course of this.
now
meeting.
the state, in order to stall the contempt proceedings, they have filed this writ appeal. Notwithstanding the matter as the matter has attained before the Supreme Court, they are trying to re-agitate the matter, which has already attained finally before the Supreme.
Let's see the file, ma'am.
Lordship may permit us to clear the objection and take it up at the earliest possible date, my lord. We'll
Just
go ahead.
come back, come back.
Now kindly turn to Annexure M, my lord, dated 2.1, 2.1, at page 100.
Was this order taken in appeal before the
Yes,
Supreme
yes,
Court?
no, 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 yeah, everything is taken, it has got a checkered history, this case. Now the kindly turn to Annexure M, my lord, at page 100, and page 100, the order which is, which I am complaining that they have not complied with. Kindly come to paragraph 5 at page 108. 108, may I read, my lord? If this is the contention advanced on behalf of the respondent, state and revenue authorities, this court should say without hesitation that the submission of the Leonard Council for the petitioners, which was recorded on 12/3/24, that this case presents a very dismal picture of the respondent revenue authorities should be accepted. This court should notice the fact that the very same submissions were advanced at the hands of the respondent, state and revenue authorities before the Honorable Division Bench in writ appeal number so and so and connected matters. It was submitted at the hands of the Leonard additional advocate appearing for the respondent state that the petitioner herein have committed an act of fraud, and as on the date of
We will
fraud.
look into it.
Pardon me? Yes.
We will see it.
And regarding the Supreme Court, they have stated in paragraph, same paragraph and also in paragraph 6. All these matters were taken up to Supreme Court and state has lost the battle. Even after lapse of 25 years. Now just for Podi and Durasti, they are putting this kind of objections and dragging in the matters. State can afford to litigate, not the poor farmers. In 109 page, last but 4 paragraphs earlier, 4 lines, bottom 4 lines. Authorities including Agriculture Department took up the matter before the Honorable Supreme Court in special leave petition number 4000, and the Honorable Supreme Court dismissed
Is
the
there ground for challenging?
No, my lord, we will clear the objection. Lordship may have it at the earliest possible date, my lord. We will go ahead with the matter. If we don't make out the
See,
case,
if you
my lord,
see
we
page 32,
please.
seeking Podi and Durasti consequent to the orders passed by this court confirming the grant in their favor and the orders passed by the court being upheld at the hands of the Supreme Court. This court therefore finds the impugned endorsement. This is declining the conduct of Podi and Durasti. Is right what he is contending.
My lord, I do not have the benefits of the writ appeal papers, my lord. It is pending.
You
for
file, you,
clearance.
how many weeks you will remove it?
My lord, during the course of this week, we will get the objection removed, my lord. Earliest possible date may be given.
Madam, my lord, my respectful submission to your lordship is mere filing of writ appeal
The issue is
is not a
covered, my
ground
lord.
to stall the contempt proceedings. Let them
Now,
segregate.
what should be done? Tell us.
No. I'm very fond. My lord.
Rightly or wrongly, they have filed an appeal.
That
Obligation on the court to look into it. We not agree with them. We'll look into it.
kindly, short accommodation.
Yeah,
kindly.
we'll do it. Just say that office objection be cleared within 1 week.
Please.
Just list on after 2 weeks. List the appeal and the contempt after 2 weeks.
7. Serial number 3.
I'm for the petitioner, my lord. Complainant.
Pardon?
I'm for the complainant, my lord.
You are?
Complainant.
Yeah.
My lord, for the accused number 2 to 4, copy, my lord, of the contempt petition does not bear the names of the accused, my lord. That being the situation, if at all he makes a mention about the names, my lord, as to the officers, that is one aspect, my lord. Secondly, my lord, I would be seeking a short accommodation to seek instructions as to the action taken by them, my lord.
My lords, the fact that the names of the officers were not mentioned was a part of defects list, and it was curated back in April, and the revised copy has not been served to them.
How have they violated this order?
My lords, I bring you to attention the order.
Did they went ahead with the construction?
Yes, my lords. And if I bring to your attention of my lords,
What is the
yesterday's
when was this order passed?
was 16th December.
And what is the present position? You have the photographs.
Yes, my lords.
Show us.
My lord, this is the photograph of yesterday.
See this page 20.
Two sets.
Now come to page 25.
Yes, my lord.
Now the left building is the one which is the subject matter.
Yes, my lords.
You have the photographs of this.
I have the photograph of yesterday, my lords.
Let's call this person.
So they covered the building with tarpaulin, heavily covered, watertight, airtight, and yesterday it was uncovered. In between also there were some flashes and which was uncovered.
Who is the person?
My lord, he is a private respondent, my lord, whom I presume, my lord, is the owner of this. I being the
No,
authorities, my
who
lord.
has done this? Who has to?
My lord, I wrote to the zonal commissioner of Bomanhalli zone, no response, no positive response, no positive action, ADTP, as well as the chief commissioner. There were only directions to AEE, but it never complied with, no sealing orders.
Just say that issue notice. The notice shall also state that the respondent number 1 shall be present in person on the next date of hearing.
Date.
4/8.
Obliged.
Just say that learner counsel for the complainant has filed a memo annexing therewith certain photographs on the certain photographs depicting the building which is under construction, which is the subject matter of the writ petition, which is the subject matter of the contempt petition, and this contempt petition as existing on 10/6/2015. You will also file in the meantime.
Please, my lord,
The
I'll state
respondents
what
2,
action has
3,
been taken.
4 shall also file
Please.
an affidavit.
Please.
Next.
My lord.
Serial number 4. Serial number 4, Shri Vardhaman Gunja.
Say none for the appellant adjourned to. Oh no, 1 minute. This is Mr. Gunjal's. Just pass over, ma'am.
9.
Lord, I appear for respondents 1, 2, 3.
Also. Yes, ma'am.
5 to 8, my lord. So 20 odd days to take this matter along.
5 to 8. No, you are appearing in 5 to 8.
5 to 8, Mr. Punjal raised that these matter be taken below. Number 50 to 53.
No, you want to be detagged those, or these should be separated
So he wants this to take.
together. We'll do that. Pass over.
Serial number 9. Serial number 9.
This is none for the petitioner adjourned to.
18-8. Serial number 10.
I was asked to implead the Rajiv Gandhi Rural Development Corporation as a party, my lord, under whom the issue in question comes, my lord. Therefore, I may be given a week's time, my lord, to bring the implead the.
Then a week's time is as prayed for, 1 week time is granted to the counsel for the appellant to file the.
My learned friend is here, my lord. I will serve the copy.
You
If the
appear
lordship
for whom?
permit me, my lord.
From the housing corporation.
Just show us the file, ma'am.
Objection. The number 3.
Just say that though on 22/4/2025, the submission of learned counsel for the petitioners to implead Rajiv Gandhi Rural Residential Corporation Limited as a party respondent number 10 was noted, so and so, but as the amended cause title was not filed, notice to the said organization could not be issued. But we find that so and so. What is your good name?
I'm representing Sumana Bali.
Just give the name, write it down, and just give it to us.
If I had informed Sumana Balika, the court has passed the order, my lord.
So and so appears for the Rajiv Gandhi Rural Residential Corporation Limited and states that he shall accept notice for the said organization. If that be so, amended memo party shall be filed within 1 week from today. Full stop. Now,
I may be permitted to incorporate the corporation, my lord.
that's what we have said.
Yes, sir.
But what about others?
Others have served, my lord. They have to.
My lords, I appear for respond number 5, my lords, Town Municipal Council.
All have been served?
Please, my lords.
Town municipal, all have been served, my lord. Our town municipal council, my lord, which is the authority, my lord,
No.
which has not filed the objections.
I pray for a week's time, my lords,
Have been
we'll file
served.
objections.
Full stop. Liberty is granted to the respondents to file their counter affidavit within 4 weeks, rejoinder 2 weeks thereafter. List on.
5-8.
5/8.
Grateful.
I may be permitted to amend the cost titles.
We have said so.
Yes, yes.
We have said.
Yes,
We
yes.
will file amended memo of parties.
Yeah, that I will do it, my lord. Before that, I have to incorporate, my lord, here.
Okay.
Yes, sir.
Additionally, the learned counsel for the petitioner shall also make necessary corrections.
Yes, my lord.
In the memo of parties.
Then I will file amended cost title.
Okay.
Yes.
Serial number 11. Sushant Tiwari.
No, this can be dismissed, my lords. Matters infructuous. Dismissed, my lords.
Mr. Tiwari fairly states that the petition, why don't you withdraw it?
I can withdraw, my lord. I'll file a memo.
Says that he shall, as the order has been complied with.
Yes, my lords.
As the order has been complied with, he shall withdraw the contempt petition. Dismiss as withdrawn.
I'm good.
Amen. Oh, just 1 minute, Mr. Tiwari. Okay. You just say this, though the contempt petition was dismissed on 27/2/24. However, closed on 27/2/24. The petitioners herein had filed an application seeking recall of the said order. Mr. Tiwari states that he shall withdraw the application for recall, being IA 1 of 24. Dismiss as withdrawn.
Serial number 12.
Appear for the complainant, my lord.
Well, I appear for the respondent.
Direction is to.
Request 2 weeks time to file objection, ma'am.
What was the direction given?
There is no direction, my lord. My writ petition was dismissed. Against that, he has filed the contempt.
Writ petition is challenging the order of the joint registrar of the cooperative societies to allot the site in my name. A positive order has been confirmed in the writ petition.
But tell us one thing, what was the direction given?
There is no direction in the writ petition. Not an administrative order. Not the society sought for a clarification before the registrar with regard to one particular site. Not the registrar passed an administrative order, which he does not have the jurisdiction. Not he passed an administrative order saying that site could be allotted to the complainant. Like challenging that administrative order, my lord, I preferred a writ petition. My writ petition dismissed. Now, my lord, he has filed a contempt on the basis of the order passed by the registrar, an administrative order passed by the registrar.
It is not administrative order.
But he has an alternative remedy of filing a dispute. There is certain dispute with regard to payment of the site.
Just wait. What is the order of which you are alleging contempt?
Joint registrar, after hearing the parties, has dismissed his petition and directed him to register the site in my name.
Where is that?
That is at annexure K.
Which page?
Ink page 69, translation at 50.
50. Translation 51.
I was allotted this
site. Alleging this has been violated.
Yes.
How a contempt would like?
When he has collected the money of 22 lakhs, still he has not given me the site on the ground that I have got my own site.
But how is a contempt?
Yes, my lord. This was challenged by him in the writ petition.
Okay.
In the writ petition, what is the observation?
By him. He has challenged it.
He has challenged the writ petition. Writ petition was dismissed with an observation, my lord, containing.
Para 15.
Before that, my lord. Para 13. It is clear at page 71. So it is clear and forthcoming from the aforementioned fact, situation that a petitioner has resorted to every possible action in an attempt not to register the site in favor of the fourth respondent. Then observation, dismiss the writ petition. When he has collected 22 lakhs, suppose writ petition was allowed. What was his defense? High Court has allowed my writ petition, hence I am not liable to pay. If High Court has rejected your writ petition, can you still have a putting argument containing there is no direction? Where is the rule of law? Every man comes to High Court, says that there is no positive direction. And there will not be any end to the situation. Now, they have filed a case against the contractor, saying that he has cheated the society by selling these sites. So contractor has taken the contention that I have not been paid money of nearly 67 lakhs. They have collected money from us. I have given them 22 lakhs.
But how a contempt?
Contempt, my lord, this is the contempt. If by this order, if he is not liable to pay, that's what I am telling already. Suppose there was his writ petition was allowed. Then what was his defense? Defense was, High Court has allowed my writ petition, hence you are not liable to get this site. He blames High Court or defends High Court order. Now High Court has rejected his writ petition. So High Court said a positive direction has been confirmed.
Where is that positive direction?
That positive, that is what I said.
That communication.
That order of the joint registrar is at page 59, 51. Under these circumstances, you are directed to register the site bearing number 219 in the name of Praveen Kumar, BN, and report the same to this office. He is directed to register the site in his name. Then this direction has been challenged. That is dismissed.
Right.
I understood.
If you have understood, what remains?
What I say, my lord, is may not be in so many words, but still I am saying, when this positive direction has been confirmed by this honorable court,
positive direction in his writ petition has not been agreed to in his favor. Simple. But we are in a contempt jurisdiction. violation of something which has been said in your favor.
That's what I am saying.
You are by implication reading into it, because his challenge to
Then
that order has been rejected, so it must be construed in your favor.
That's what I am saying.
Sorry.
Court may record may say, ultimately rule of law is when he comes to higher court, if lower court order is confirmed, high court can dismiss it. Whether it emerges in the
Not surely in these facts. Not surely in these facts.
Just this is a fact.
That's right, but we are not in agreement.
Then where we should go? To 22 lakhs.
Can't you tell us one thing? Just 1 minute. Is writ petition dismissed? Whether whosoever is the authority joint director or whosoever is not implementing the order in your favor?
No.
He's not. File a writ petition saying that this is the direction given.
Then my lord, what I say, my lord, is instead of Dravida Pranayama, can I not file contempt petition?
We are surprised. Why did you file a contempt? You should have filed a writ.
That's what I am saying. In my humble submission, when a positive order is confirmed, ultimately court.
We will not. See, this is then we are, propounding a new law.
Yes, I do consider ultimately jurisprudence means it should be taken developments.
Not
in such a circumstance, when a positive order, then he may say writ petition, then a writ appeal, then Supreme Court, then where shall I go? Ultimately, it is not rule of law.
He can't answer that.
I answer. I understand. It is not rule of law. My money is held up with them. They are cheating so many persons, and they are giving false evidence before this honorable court. And so contractor of the society says they have not paid me the money. They have filed a criminal case against him, and criminal case is dismissed. Now, with all these background, is it not a contempt? Civil court, the high court order is disobedience. What is the interpretation of the high court order? Interpretation is order, positive order is confirmed. Ultimately, fact remains the thing. And if hair splitting argument, there is no direction, positive direction. A positive direction has been confirmed. I am repeating the cost of repetition. Suppose my writ petition was allowed. Then what was his defense? Defense was high court has confirmed. So he takes shelter on the high court order. Now same time I am taking shelter. Your petition is
right. You should have filed his petition dismissed. The orders were implementable by the concerned authority. They have not implemented. I have come to you for a mandamus.
Then what is my difficulty? My difficulty is he should go, notice should go, no should go. By the time the contract already is bifurcated.
We can't answer all this. You have filed a contempt. Instead of contempt, you would have filed a writ petition. Simple.
No, only one. I understood what is going on in courts. I understood. But as an ordinary citizen's matter, simply 2 minutes time. Suppose if already the contractor has bifurcated this site in part A, part B, society complains against the files criminal complaint, saying he has cheated the society. In the criminal court, he files a defense, saying society has not paid me any money. 29 lakhs society has to pay us. So criminal court rejects his complaint, B report is accepted. Now what is that they're doing? Where is the reasonable defense for not to obey this order? Indirect way of order is
there would be objections coming against that we can't implement this order for ABC reason. Instead of it under contempt. That angle the court has not. Right. But when he filed a petition with objection, then that angle will be seen. Will be seen by the court. The court should not see it as
well, already we have lost 1 year. After filing of the complaint, 1 year elapsed. In the meanwhile, he has divided the site into A, B. Already B is sold.
You must move fast. Must move fast.
I understood.
You want to withdraw this?
I understood. Not that I am not understanding what the court says.
No, we are not saying so. We are saying so. You understand everything, but still you don't want to withdraw it.
What I wanted is there shall be not multiplicity of the proceedings.
We will not take that. Multiplicity, so you have filed a contempt. If you had filed a writ petition, contempt would not have been there.
One thing is, when after hearing me only, courts felt that it's the
Very
contempt.
well, we will pass orders then. Just say this.
May I make one more submission?
Withdraw it and file a
Allah,
contempt,
only
we'll
one more
record your
sub-
submission.
Allah, one more submission.
Yes.
In the meanwhile, let him not alienate the
He will
site.
not say so anything. You will say so in your writ petition, seek an interim relief before the concerned court.
Allah, the interim ಅಲ್ಲಿ ಕೇಳೇ ಕೇಳ್ತೀನಿ. I'll ask in the same period.
That's right, do that. Not in contempt, let's be clear. And there is a huge issue on the maintainability of the contempt. There is actually an issue, and that's what we are putting it to you. Whether this contempt is per se contempt maintainable in the facts. Yes, you want to, we will record your submission. You want to withdraw it and seek such remedy as available in law. Seek your remedy.
ನನಗೆ let it be called tomorrow or Monday. I will ask my tomorrow or Monday. I will ask.
Why?
I will ask my party. So
Pass over.
what he want. Monday. prefer
Pass
Monday.
over.
Allah,
Take instruction.
Allah, I should.
Okay. At the request of counsel for the petitioner to take instructions, re-notify. Just give it next week.
Tomorrow or Monday.
What we were giving next week.
Much clear.
Okay.
Much obliged.
18-6. Bill number 13.
Come to the point. There is a statement. Yes.
The last occasion, notice has been ordered.
Let me just show us the order sheet. What are your instructions?
On 9/5/2025, we are communicated to the complainant herein, my lords.
What have you communicated?
We have communicated, I'll file the compliance affidavit. We have communicated to the effect that grant is there, but possession is not there. In light of that, because of the circulars governing us, we are unable to effect the Podi and Durasti as such, my lords.
You have filed all the documents.
Yes, ma'am.
So where is that letter? 9/5.
9/5/25 communication, I have shared it with the complainant.
Have you received it? 9/5/25.
Rashma kindly say, pursuant to this order, whilst the parties have come to the authorities have come to the spot to conduct this survey, one person has objected. That objection has been treated as a letter and rejected that letter, against which an appeal has been filed by the other party, that is the government. Even that appeal also has been dismissed. Thereafter, they have moved the second appeal before the deputy commissioner. That also has been dismissed. I will file a better affidavit also in.
Direction is simple.
Yes, madam.
Online Podi and Durasti of their lands with all particulars in the manner known to law. Upon such application, respondent will take appropriate action in accordance with law on seniority basis as expeditiously as possible.
Yes, true, madam.
They say pursuant to this, they have sent a communication dated 9/5/25. Are we to take it that his request, whatever is the request, has been rejected?
Very much, my lords.
Has been rejected. The remedy would be to challenge that. Do you have that 9/5/25?
I've also shared it with the complainant as such, my lords.
No, shared it. Does he have it? Do you have it?
Yes, ma'am.
You have to challenge that. So what do you want? You want to withdraw this?
It may be closed, we will take appropriate
That's
action
right.
against the tender.
Very right. The learner counsel for the petitioner states, petitioner concede that the impugned order or the order of which non-compliance is alleged has been satisfied in as much as, no, has been complied with, has been considered and complied with in as much as the respondents have issued a communication dated 9/5/25. Though rejecting his request, he states that the petitioner shall challenge the said communication in accordance with law in appropriate proceedings. The contempt petition is closed.
Lord, a small submission, Lord. I appeared for a complainant as a previous counsel, my lord. I have given NOC. My name may be kindly deleted.
Just call the counsel. Have you filed your wakalat here?
Today I'm filing it, my lord. Today they have given.
Where is the wakalat? Just give it to the court officer.
Yes.
Just take it on record, ma'am. Just go, give it to the court officer.
Yes,
Just see it, ma'am, complete. Then so and so, the counsel has filed a wakalat on behalf of the petitioner. The same is taken on record in view of the fact that so and so has now been engaged by the petitioner. Mr. Vinod Prasad, what is your good name?
Trivikram, yes.
Trivikram S is allowed to, on an oral request, is allowed to retire. Okay, is it fine? Amen. Just affix the stamp also. Just affix it. Just affix it and let it be filed.
Yes.
Next.
14,
Much obliged.
will complete.
14.
14,
None for the petitioner, adjourned to.
It's case 14.
Yes. Yes, Mr. Bhatt.
It has to be complete, my lord. The award has been, they have been directed to pass the award. My lord,
What are instructions?
KIDB is the answering respondent.
Pardon?
KIDB is the answering respondent.
Who appears? Ma'am, notice issued.
notice has been served. my lord.
Served and unrepresented.
Served unrepresented.
Who appears? Who is the officer you have named in KIDB?
Land acquisition of.
Tejas Kumar, the special land
Is
acquisition
it
officer,
still,
2
is still the land of LSE?
Yes, my lord.
Is it still the LSE?
Yes, my lord. No, there is no LSC.
No, no. This, you said Mr. Tejas Kumar.
Tejas Kumar
Is he
is
still-
still there. Yes, my lord. He is still there.
He's still there.
Yes, he is still.
Just say that service affected, ma'am, on respondent number 2. Just say this, there is no appearance for respondent number 2, those served.
On last occasion also, they were not present.
Was the submission of Mr. Butler, counsel for the contempt, the petitioners, is that despite order dated 8th January 2010.
No, that was the first one.
That's the first order. Which is the order of which non-compliance alleged. 9/10/23. 9/10/23.
Already, okay.
9/10/23, wherein in paragraph 11, the following has been stated, ma'am, page 81, ma'am. The following has been stated,
19/2023.
Page
comma,
71.
the directions have not been complied with. We find there is no appearance for respondent number 2, the officer who has to comply with the order. Despite service, Mr. Tejas Kumar, the special land acquisition officer 2 of KIADB shall be present in the court on the next date of hearing.
five, 8, 15, serial number 15.
Please. Madam, I am for the complainant in the above case. This is the case for workers' gratuity in concern.
What are your instructions?
My lord, as far as order is that I have to consider their.
You appear for official liquidator.
Yes, ma'am.
So how do you, what is the defense? These are statutory dues, no?
Yes, please.
These are statutory dues.
My lord, may I sub? My lord, there are statutory dues. There are about 430 employees. The employees where the applicant, he has taken an order from this honorable court for a direction to the official liquidator to consider their applications and pass an order. Your lordship may kindly see the order where, yes.
25.
I have considered that applications, I have passed an order
And I have paid a part amount also to them.
Where is the order?
No,
Where is the order?
I have already passed an order.
But we should see it, na? You have passed an order or not? Where is that order? Have they passed an order?
No, sir. No, sir. Not yet paid.
No.
Not yet passed any orders.
My lord, I have filed objection.
Where is the objection? Show
Yes,
us.
my lord.
In the company petition, they have not filed any objections. They have only submission, oral submission.
This is,
I
In
have filed
page
objection.
number 43. 43. The respondent officially is directed to consider the claim of the applicant for the payment of gratuity in terms of following orders of this court. So and so. Lastly, third part, liberty is reserved in the favor of the applicant to submit pleadings and documents of the office executive to enable the expeditious consideration of this claim. The respondent office executive is directed to proceed further and take necessary steps pursuant to this order as expeditiously as possible within outer limit of 3 months from the today. 12/7/2023 order was passed. Even now they have not paid single pi, and they have filed the objections. They have reply.
1 minute, let's be
Please.
clear. Let's be clear the scope of the order.
Please.
What it says is to enable official liquidator to re-adjudicate their claim after obtaining necessary documents.
Yes, please.
The respective claims which are the subject matter herein stand remitted to the official liquidator for re-adjudication of the matter.
Yes.
Now he, according to the council, he has adjudicated the matter afresh.
No, we have submitted our representation. They have not adjudicated.
1 minute, not
Please.
adjudicated in the manner you want.
Please.
Has adjudicated the manner which he deems it fit.
Please.
If you have any grievance, you will seek such remedy available. But to say that what you have said should be allowed or agreed to, that possibly would not lie part of the contempt.
Please. One
Okay.
I submission before this honorable court. They have not denied our claim. As page number 30, page number 3 in their report.
Want to know where is that order where the official liquidator has passed?
My lord, that order copy I have not produced. My lord, your lordship may kindly see my objection, para number 4. My lord, I have given a tabulation. Para number 5, my lord. I have given the petitioner's name, gratuity amount entitled, amount paid, and balance amount payable. I have already paid this amount to them. Part amount I have paid. Available, my lord, read it like this, my lord.
But you also say paragraph 10, last 3 lines. Hence the official liquidator.
My lord, there are other 400 employees which they have not claimed gratuity to me. I am required to pay this. I have balance amount of 5 lakhs and odd, my lord.
Now, how many petitioners were there?
My lord, petitioners are about 14 petitioners, my lord. Now here, my lord, there are 14 petitions.
We are concerned with 14 only?
Yes, my lord.
How many workers have filed the claim before the
My
company
lord, these
court?
14 members, they have filed, my lord.
14?
Yes.
Okay. 14 or 10?
14.
14.
Presently, 10 petitions are pending before this court.
No.
Oh.
See, come to page 27. There are 10 here. Now let's assume 14 have filed.
I have adjudicated over 14, my lord.
You
Para
adjudicated
number
14?
5. Yes, ma'am.
The petition, the claim before the company court was only with regard to 14? Okay. Now,
Yes.
out of 14, if you see the chart at page 8 of their objections,
Yes, please.
now, but what about balance payable?
My lord, balance amount, I have 5 lakhs and odd balance amount is available with me, my lord. Now, my difficulty is about 400 other employees have not filed any amount, any claim to me. I have not paid any amount to him.
I have paid part amount to them. I have not paid anyone 1 rupee to the other claimants. If they file a,
When they will come, you will work it out. There, see,
if the file claim, now if I pay this amount to them, I will be left with no amount. If the
we
file,
don't know. We don't know.
no, I have said that, my lord, I have, the balance available with me is only 5 lakhs.
We don't know.
No, I have filed my,
Very well, you may have said so. What we are putting it to you is this. They are entitled to gratuity
Yes,
in
ma'am.
law.
Yes, ma'am.
Whatever they have come, they sought directions, they got the directions. And you are not denying the entitlement of the gratuity in the manner they are saying,
Yes,
or in the
ma'am.
manner you are saying in this page. Whatever amount, whatever gratuity they are entitled, they will, if the others will come, those claims would be adjudicated and you have to pay. How would you pay?
my lord, I have no other property to pay, my lord, I have no other amount to pay to them.
See, they should approach.
Assets of the
He say he doesn't have the assets. You don't have the assets.
My lord,
You don't have the assets.
address, my lord, I have to find out.
Assets.
assets.
My lord, I have to find out.
Company has the.
Assets, my lord, I have an assets, my lord, it is still pending before the
Well, you
division
will
bench.
pay- you
My
will
lord,
pay-
it is pending, my lord, there is a dispute between the.
One
assets,
request,
ownership, my lord.
one request, this honorable court,
One-
please.
the-
Para number 12, already 23 lakhs lying with the office liquidator. And only our claim is only 11 lakhs, total 14 members.
No, not 11 lakh. They say
Total 11 lakhs. Page number 3 in their reply. Page number 3 in reply.
They say payable is 95,428. If you
It
see
is,
page 8.
yes, please. But it is,
My lord, para 12, my lord, the balance amount left with official.
it is for
liquidator.
arrears of salary, not the gratuity in this concern. Please, as per para number 3, as per our gratuity, 11 lakhs only. They are having money, 23 lakhs as per para number 12.
Yes, you take instructions. As and when they will come, you have any assets, that dispute will be resolved first. You will work it out, you will pay from the assets.
My lord, if the assets are in favor of the official liquidator, my lord, confirm, my lord, then I can sell the assets and pay, my lord. If the assets are, if the other way around, my lord, I'll be left with no amount to pay to any amount to any other claim.
That's
When they have got part of the amount, my lord, other claim, my lord, according my this thing, my lord, I have to give each employee a certain amount, my lord. I cannot deprive the any amount to, so each amounts to, my lord, I will be depriving no amount to, I will not pay any amount to other employees, only pay to this people.
Very well, very well. It's true, you may say so. But did you work out, did you made an attempt to
I will.
Made an attempt to ascertain who are those employees who have to be paid gratuity?
Yes, ma'am.
What happened?
Well, if they don't file this.
Exactly, we are on that.
Then I am bound to pay this balance amount to them.
So have they filed any claim?
No, till today, my lord, they have not filed anything.
So why should they be not denied?
No, I am not denying that amount.
So, see, you can't argue both. See, I have to pay the other employees who have not made a claim, but they have not made a claim, but I will not pay them.
No, I never said I will not pay the amount, my lord, since I am required to pay the other employees, my lord, bound under 529A compulsorily, my lord. It is only this request, my lord. When these employees have got certain amount, other employees have not got any amount, I may be permitted to work out my remedy to see that whether employees I can, otherwise, if no one is coming forward, then I am bound to pay to them.
For how long or when were the directions given in their favor?
12/7/2023. Last 26 years they are waiting, please.
23 till now, the other employees have not come forward to make a claim. For how long you would wait and deny them the benefit?
My lord, as and when I sold the property subsequently only, my lord, I have.
That you can say for them also, the others.
But I.
First come, first serve, you pay. And then after selling, you can say that I will satisfy the other claims.
Because, my lord, as per para 12, my lord, I have balance of 5,92,000.
Already 23 lakhs is there. 23 ಲಕ್ಷ ಇದೆ ಇದರಲ್ಲಿ. 23 lakhs already is there. Our claim is only 11 lakhs. ಅವ್ರು ಇನ್ನೊಬ್ರಿಗೆ ಕೊಡಬೇಕು. They have to pay 17 lakhs. They have to pay, no claim at all. No claim application before the pending.
May I read only paragraph this one? At para 12, my lord. At this juncture, official liquidator has 23,01,292 to the credit of the company in liquidation. Consists of 17,09,226 received from MKL gratuity fund and other realization such as interest on investment, FD, so and so. Since 17,09,226 belongs to the workers who have not claimed their gratuity, therefore, the official liquidator is not supposed to utilize that amount. The balance amount left with official liquidator as on date is 5,92,667. The security charges are being paid from the time to time.
CH-2. But he has come in contempt. So official liquidator will decide it. So he has decided the claim not paid. The thing is, see that on the official liquidator. Of the learned single judge. Stand remitted to official liquidator for re-adjudication. But tell us one thing, how will a contempt lie now?
That is.
You see the direction? Page 25. See, after adjudication, they have paid only this, and the rest they are not paying.
I filed this claim application on order on 12, page number 40. I filed this application on page number 40 on basis of the order on 40.
Right, come to the direction.
Yes. Order.
See paragraph 15, page 25. That's right, that's the order. That is the order of which you are alleging contempt?
No, sir, 40 case. 40 page
40,
number. CA 102 of 2021.
But operative portion 44. Liberty is reserved in favor of the applicant to submit pleadings, documents of official liquidator to enable the expeditious consideration of his claim. Respondent official liquidator is directed to proceed further and take necessary steps pursuant to this order expeditiously as possible within the outer limit of funds.
Shall we do?
My lord, if I am not paid any amount, my lord, see, maybe that there is a violation. If I paid a certain amount, if I am not paid according to him full amount, my lord, there cannot be a contempt as such because I have complied that order. The availability or not availability, it is for the company court to decide.
C44. See page 44.
Yes, my lord.
Liberty is reserved. Respondent then 4. Official liquidator is directed to proceed further and take necessary pursuant to this order expeditiously as possible within a period of. So what it says is liberty reserved in favor of the appellant to submit pleading documents to the official to enable expeditious consideration of his claim. Then he will take necessary steps.
I have taken necessary steps and paid part amount to them.
But that is not a complete necessary step means the
Malad,
complete amount.
Malad, it is
After filing this, after this order, they have not paid single pie.
Whether I have paid a full amount or part amount, Malad, whether they are now I have to pay the full amount basing on the other claim, other employees that which I have to pay. It is for the company court to decide, Malad. It cannot be decided in a contempt proceedings. That is my humble submission. If you can make Malad, one request, Malad. If you can make an application to the company court, direct me to pay this.
Don't you go to company court again?
Yes.
It is a company court orders. I request this honorable court for the last 1/1/2000 company was closed. 1/4/2004 company liquidator was appointed.
Right. You're right.
Here, I have filed application before the company court.
We have known, we have seen that.
Please.
What is being contended is this. I have paid some partial amount to you.
No, after this order, they have not paid single pie.
You're not understanding, you don't want
Please,
to
please,
listen to
please,
us.
please, please,
Difficult.
please,
We are saying some amount has been paid, not the complete amount.
please.
The ground which is being urged is, look here, it is not only these workers.
Yes.
I have other workers. There is a likelihood the claim may come from them. Now he wants to be fair, saying that at least some amount should be given to everyone. Just listen to us first. We don't know. That can be an argument, because ultimately if a person is entitled to a gratuity, he is entitled to complete gratuity. It is not a case where there are no assets. There are assets. Those there may be that some assets are subject matter of a litigation. He says, suppose if I succeed in that, I get that asset, I can sell that asset and pay everyone. But in the interregnum, the others would come. I want to be fair. At least some amount should be payable to the others also.
That is all.
That's the sum and substance of his submission. So what we are saying is, what is being suggested is this. Will it not be appropriate for you to approach the company court saying that this is the stand which they have taken? This stand is not tenable in law. If I am entitled to 100 rupees, I must get 100 rupees. Further, you can argue that if the others have not approached making a claim for gratuity, why should you be denied the complete benefits? You can argue that.
Yes.
So will it not be appropriate for you to go to company court and argue?
Yes.
So the company court will decide that very well, this is the stand.
One submission before this. All these contentions submitted before this court only. In page number 42, at least their incapacity to pay the money before the company court. At para number 5, is there any objection filed before the company court? Para number 5 in page number 42. Per contra, learned counsel for the respondent officially could submit that there is no merit in application and the same is liable to be dismissed. Except this para, is there any calculation? Is there any money available or not? Is there any piece of document to produce before this company court? What defense they have taken? What difficulty they have submitted before the company court? For the last 26 years, we have suffered a lot, poor workmen. Even now, they are not ready to, at least what amount we are ready to pay the money. At least they have not filed any objections in written. Now only they appear before this court, they have filed the detailed objections. Only one ground, no merit in this application. What balance they have, what property they have, what is the difficulties? At least they have submitted before the company court. As and today they have 23 lakhs is there. Our claim is only 11 lakhs. Except this 14 application, they have no single claim application before the office liquidator.
Are there any further claims which are pending consideration?
Malad, that I'm sorry.
Almost 32 acres of land is pending before for.
Yes, one.
Well, I'm sorry, Malad, right now I don't have direct information.
No,
but
what
I
we
can
are
find
asking
out.
you is this.
Yes.
Has any other employee approached you for gratuity?
Malad, I have to get instruction.
If they have not, you can't wait till time immemorial and just say that the gentleman would come make a claim. In the eventuality the claim is allowed, I must have something to pay to him. Then only, that can't be. They are the people who are really asking you, please complete. Take instructions. If there are none whatsoever, there are no other employees or no other claim made, and you must complete the payment to them.
I will, ma'am.
Just we have heard the counsel for the parties for some time. The issue which arises for consideration is that whether the petitioners herein are entitled to complete gratuity amount pursuant to their claims having been adjudicated by the learned official liquidator. The submission of learned counsel for the petitioner is that the complete amount is being denied to the petitioners herein only on the ground that there is a likelihood that some other employees may also make a claim for gratuity. And in that eventuality, some amount need to be paid to those employees on a specific query from the court as to whether any of the other employees have approached making a claim for gratuity. The learner counsel for the petitioner seeks some time to take instructions. Okay.
Respondent, I am not seeking time.
Respondent.
Respondent, please.
Seek some time to take instructions.
Yes, please. I will.
(15)(2).
20, my lord, some office objection one is there, my lord.
15 to 26.
I have not given a copy, but I have already given a copy, my lord, that.
Copy of what?
Reply have received.
Huh?
I received the copies, replies.
You have received?
Counter, my lord.
Yes, please.
I have that counter, my lord. Costly says that there is an office objection that I have not filed, given a copy of the counter to
We
him.
take on record the submission made by the
I have
learned
already
counsel
given, my lord.
for the respondent that a copy of the reply has been given to the counsel for the.
Yes, we have received.
Counsel for the petitioners. Hence the objection, if any, is overruled till 26, man. Till 26. Next. We will tag it together. Let it be a common order in all.
Up to 26. Please.
Just give a date, ma'am.
5/8.
Huh?
5/8.
5/7.
5/8 August.
5/8. Obliged.
27. Serial number 27.
I'm appearing for complainant, my lord. I request for a passover, my lord. We'll argue. They have not complied the order. We have filed rejoinder affidavit. It is on record.
Who is the counsel? Yes, what is the order? Just show.
Passover, my lord. Sin is on it.
Yes, Mr. Ranga, what do you say?
May I request for a passover, my lord?
I filed an affidavit.
Passover is difficult today. Will not be able to.
Lord, I have
pass over.
filed an affidavit. They have taken, they have filed a rejoinder also, my lord. I'll just show that there is compliance of the order.
So that order may not be. The order may not be correct. Yes, what were you required to implement?
My lord, there was a scheme called ABT, which is, my lord, appointment by transfer. So far as, my lord, the complainant is concerned, initially, my lord, when he wanted to opt, basically, my lord, appointment by transfer is, he is not a graduate when he joined service. If he acquires, my lord, a degree BE in electrical, he can apply to say that now that I have become a graduate, you appoint me as assistant engineer graduate. That was possible at that point in time, my lord. That scheme was there. He had some criminal proceedings against him, disciplinary proceedings, etc. His application had not been considered at that point in time. Lord, he approached this honorable court in a writ petition, wherein, my lord, ultimately, my lord, in the meanwhile, the scheme had been withdrawn. But because this issue was lingering, my lord, there was a direction that because it is not a promotion and it's an appointment, don't go by the pendency of criminal proceedings, etc. You consider it. That direction, my lord would find it is extracted in the order, my lord, violation of which is complained of.
But the criminal proceeding will come even in direct recruitment.
It should have, it will have a bearing, my lord. But anyway, ultimately, he succeed in the criminal proceedings. My lord, disciplinary proceedings also, my lord, 2022, he gets
acquitted.
Yes, my lord, in both. Now, my lord, what happened is, in the meanwhile, he was given a pro forma promotion, my lord, with effect from 5/5/2018. He anyway had become an assistant engineer from 5/5/2018. The judgment of this honorable court, my lord, in his case, indicates that it is not a transfer, it is an appointment. Considering all this, my lord, relying on judgment of the Honorable Supreme Court also, my lord, kindly see the order that has been passed, Annexure R1 to my affidavit of 19/8/2024, reporting compliance.
Yes.
Lord, the entire background is discussed at ink page 8.
What was the direction in 5902?
To consider, my lord, his request for appointment.
What is this writ petition 5902? 5097?
5097 of 2019, my lord, is his writ petition.
Earlier writ petition?
Yes. His writ petition, my lord, my lord, directing that we should, my lord, consider his application for appointment by transfer in spite of, my lord, all those criminal proceedings, etc., which were pending.
Now, what is the order you have passed? This order you have passed?
Yes, my lord, Annexure R1 is the detailed order, my lord, I have passed.
What have you done? You have denied it?
No, my lord, I have granted. My difficulty, my lord, was because it is an appointment. Unless I can only, my lord, appoint him from the day on which, my lord, he takes birth. It can't be a retrospective appointment. Therefore, my lord, he was given a pro forma promotion on 5/5/2018. So, my lord, I have appointed him from that day.
Oh, you appointed him?
Yes, my lord. That is.
But it would be a sort of a, performer means he would not be entitled to any benefits.
Lord, this whole issue of ABT and this, Lord, promotion, etc., everything, Lord, is subject matter of various proceedings which are still pending, Lord. This because of, Lord, Pavitra judgment and Gurumurthi's judgment, Lord, which all emanated from, Lord, this particular organization, Lord. Everything is in a flux. We had to do and redo those lists, etc. So far as ABT is concerned, my lord, there is a litigation which is now pending in a writ appeal between general category, my lord, which directly gets recruited, and ABT, my lord, as to who will be senior to each other and what should be the, status given to that period which they spent in the earlier cadre, my lord. All those issues are pending. That is also mentioned, my lord, in my affidavit, to say one of the reason why there was delay is this pendency of writ appeal 362 of 2021.
Yes, what do you say if you see this order?
Please, madam.
What do you mean by the compliance of the order? The order says, if you see the order, endorsement is quashed, matter is remitted to the respondent to take decision in the matter in the light of the observation made within outer limit of 6 weeks.
Please,
so what have they done? They have done, if you see page 9 of that annexure R1.
They have given me pro forma promotion from 5/5/2018.
That's right.
My claim is that, my lord, I'm entitled from 2012.
Why?
When my juniors are promoted, my lord.
No, he said
without resorting to any criminal cases, my lord.
Not promoted, appointed.
Appointed. I'm sorry. I'm claiming from 2012.
But why do you say from 12? Who is that junior?
Please,
who is that junior?
He says, my lord, there is one person by name
And tell
Harish.
us one thing, Mr. Ranga, just what is the sanctity of this date of 5/5/2018?
Lord, he has taken birth in the cadre of assistant engineer on that day. Therefore, my lord, I have appointed him from that day. It cannot be prior to that because of the.
He didn't have the qualification.
No, my lord. Therefore.
Did he have the qualification?
He had the qualification.
In the year 2012 itself.
He had qualification, but my lord, I can't appoint him retrospectively from an earlier date, my lord.
But tell us one thing. Then why did you do it from 2018?
Because he has taken birth on 5/5.
No, but he's according to him is in 2012 birth.
No. My lord, he continued to, my lord, be in the earlier cadre, but he took birth in this cadre, my lord. By if I have to appoint him,
that's what we are asking you. This cadre means which cadre?
Assistant engineer.
Electrical graduate.
Yes, my lord.
Okay. Now, did he get the qualification eligibility for this post on that day?
He had become an engineer earlier, but my lord, he had been promoted. Pro forma promotion had been given from 5/5/2018. Therefore, he had taken birth in the cadre on 5/5/2018. Therefore, my lord, I have retrospectively appointed him from the day on which he had took birth in the cadre.
Before you passed an order, he also got the promotion from that day.
Yes, my lord. Yes.
Assistant engineer.
Yes, yes,
Very well.
yes.
Now, that was on the strength of the qualification or the eligibility which he was having minus the graduate. Are we right?
Yes, my lord. Yes.
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 So that was a normal promotion he got.
Yes.
What is the benefit he got because he acquired graduation or a graduate qualification in engineering? There must be some benefit. Okay, you're getting the point. So if that be so, that benefit need to be given. Na? What is the use of getting a graduate qualification and his promotion or appointment only relates to the normal date of promotion? That can't be. There must be something more.
Lord, his seniority is also refixed based on that, my lord. Therefore, my lord, he gets into the, my lord, stream of graduates.
That's right.
Because there are two parallel streams, my lord.
Okay. Just
one is promotees and, my lord, graduate.
When did he acquire the graduate qualification? 2012.
2012.
2012.
So that's the point. So if in 2012, you are confining to the date of the normal promotion.
Lord, my only difficulty, my lord, is that before he, my lord, takes birth in that cadre, my lord, I can't make an appointment, my lord, retrospectively. Because it is an appointment. It is not a promotion. If it was a promotion, my lord, this honorable court, in its order, my lord, specifically said that it is not a promotion, it is an appointment. Kindly see
You're
that.
right. Then I think that may not really help your case. Because promotion is subject to eligibility. Appointment, what are the eligibility condition, on which date he acquired the eligibility for appointment. According to him, as a cadre, in the cadre of assistant engineer, electrical graduate, I acquired the qualification in 2012. So 2012 must be the date. Otherwise, you picked up only on the ground that he became assistant engineer in the normal promotion channel from that date. So what is the use? No use. In fact, I got that promotion in normal course only. But since I have acquired graduation, there must be some benefit which must flow.
Not because he switches, my lord, from one stream to another. There are obvious benefits, my lord. His all consequential benefits are also granted, my lord, by the impugned order.
Let's see the direction which has been given.
Page 21.
Now, would it not be, now we are putting it to you, would it not be that you should challenge this order which they have passed now? The direction is to take a decision in the matter.
Please, my lord.
Rightly or wrongly, they have taken a decision.
Please, my lord. But this is the second round of litigation, my lord. They have done the same thing.
This is the
Again,
one,
I have to approach
page
in-
21.
Please, my lord.
This is the final direction of which
Yes,
contempt
my
is
lord.
alleged.
Yes,
Please,
my
my
lord.
lord.
They have passed an order, they have taken a decision. They say, this is my decision.
Please,
You will challenge that decision.
I may have to challenge
Can't
the
be a
endorsement, my lord.
matter of contempt. Can't be a subject matter of contempt that we are deciding in contempt whether the date which they have fixed is 2018 or it should be 2012, which you are contending.
Please, my
We will not decide. You will file a fresh proceedings.
My request for tomorrow, my lord. I'll take instruction. My request for tomorrow, my lord. Please, my lord.
You have to just answer this.
Please, my lord.
Okay. Then, if you say so, you will challenge. We will relegate you to fresh proceedings
Please, my lord. Wait.
tomorrow.
Great.
Serial number 28, Shri Nitin Ramesh.
Lord, I appear for the complainant, Lord.
Matter, my lord, pertaining to the settlement of pensionary benefit.
Till today, the pensionary benefit
What
has
is the
not been
direction?
given to us. The Lordship
Direction
may
of
kindly
this
come.
honorable court, my lord, the endorsement issued by the accused number 2, my lord, came to be quashed by the Raichur University. Pay the entire pensionary benefits.
What happened? What is your case?
My lords, may I make
Who
my
appears?
case,
You
my lord?
appear for the petitioner?
My lords,
Yes.
I appear for the complainant, my lords.
Yes.
My lord.
At 31 lakhs, my lord, what happened, my lord?
I was working, my lord, may I make my submission, my lords? My learned
Yes,
friend,
yes.
Please. My lords, I retired as a professor in the accused number 1 university, my lords. At the time of superannuation, the endorsement had been issued saying that the new pension scheme would come into effect for me. But which endorsement I challenged in this honorable court by way of a writ petition. This honorable court quashed it. Consequently, it became clear that my resignation from the earlier university, I was working in Raichur University. From Raichur, through a proper channel, through technical resignation only, I came into the accused number 1, Bangalore GKVK, University of Agriculture Science, Bangalore. Now, because the writ petition went in my favor, it is clear that I am entitled to old pension scheme allowance, not the new pension scheme. Now here, if your lordships were to kindly come to the direction, the ink page 28, my lords. In
Yes.
this, there are second and third directions, if I may please, my lords, for your
Yes.
lordships' attention. The impugned endorsement bearing so and so issued by the respondent who is hereby quashed, which means, my lords, the issue of NPS and OPS is resolved there. I am entitled to old pension scheme. The third one, respondent number 2, that is my earlier university, Raichur University, is hereby directed to forward the entire pensionary benefits payable to the petitioner to respondent number 3. This is Bangalore, from where I superannuated, within a period of 8 weeks from the date of receipt of a certified copy of this order. Now, if your lordship may kindly take the objection filed by the University of Agriculture Science, Bangalore, I'd only point out how they have made, in fact, admission of the fact that they have not cleared the pension, but the reason made out is, your lordship may kindly take the statement of objection filed by my learned friend appearing for accused number 1.
Tell us one thing.
Please.
This University of Agriculture Sciences,
Please.
both respondent number 2 and 3 are different entities.
Yes, yes, my lord. They are two different entities coming under the same state university, my lord.
But different entities.
Different entities.
And you were initially in 2.
Please.
You came to respondent number 3.
Please.
Now, the direction.
Through technical resignation, my lord.
Was there any direction to count
Yes, my
the
lord.
period?
Because my application was through the proper channel, and with the approval of my previous university, I was allowed to seek appointment in the new university.
In respondent number 3?
Yes.
Okay. So you are saying that period be to be counted?
Yes, my lord. My lord, the fact that technical resignation happened, therefore there was continuity of service, it has already been held in my favor by the Honorable Writ Court.
I appear by the respondent. I have filed the joinder, my lord, objections, annexure R2, my lord.
What do you say?
I have complied the order.
No.
My lord, may I only read one paragraph before my learned
Counted
friend
is earlier.
Only one paragraph.
How many years you had put in 2?
My lord, we signed on 1/4/2009, my lord, to 16/1/18.
Up to 2018, my lord.
For that period, I have counted and forwarded to
Forward to 2.
accused number 1.
For 3.
As per the direction, my lord.
No, direction is to 3, no?
3 here accused 1, my lord.
That is a respondent.
Number 1.
Here it is only 2
Here
accused.
respondent number 3, my lord.
He directed to forward the entire pensionary benefit payable to the petitioner to respondent number 3 for further action.
Yes, I have forwarded, my lord.
You have given to 1
Before
or 3.
my learned friend.
Just 1 minute, please. Just 1 minute. You have given it to 1 or 3?
3, my lord.
You have given to 3. You are for 3?
May I request, my lord? 1/7/1986, my lord, initially appointed, my lord, Agriculture University, Dharwad. From up to, my lord, thereafter, my lord, from 31/3/2009 to 16/1/2008, again he appointed Raichur University. Thereafter, my lord, he appointed present university, my lord, on 17/1/2018, my lord, 6 years, 3 months he worked in my institution as a by way of direct recruitment. It covers, my lord, NPS, new pension scheme, as per the government order. Now, my lord, the Raichur University, for a period of 18 years he worked. They issued an endorsement stating that he does not covered by the NPS Because a continuity of service, you have to pay the full pension transfer to the Bangalore Agriculture
We
University.
don't, to be, at least what we feel is.
Please, madam.
Once they're discharging the pension.
31 lakhs they paid, we have already dispersed to the petition complainant.
1 minute, just 1
Complainant.
Once they are discharging their liability for the period he has worked to
Please,
you,
madam.
they are giving it to you.
Please.
You have to give that period, this period, and give it to him. But what is the difficulty?
Complainant is disputing against the Raichur University because it is not a full pension. It is only a contributory pension has been paid. Therefore, they are disputing.
No, madam, they are not disputing. For my objection.
Is it your pensionable service? Yours is a pensionable service?
Yes, madam.
It's a pensionable service. Like yours, it is also a pensionable service.
They are disputing, my lord. I had given a calculation of 1 crore 23 lakhs is liable to pay by the Raichur University. Instead of that, they paid only 31 lakhs. For which, my
Wrong
lord?
calculation.
No, for 6 years, my lord. He required to submit a PRAN number.
How much they have given it to you?
My lord, 31 lakhs, my lord, I produced the copy also.
Yeah,
my lord.
R2, my lord. The checks I have paid. Annexure
Lord,
R2.
may
my lord.
kindly see
You
the
come back
statement
after
about
mention
such.
it, please. My lord, I produced the copy also, how much we have
You will
paid.
see that.
My lordship, kindly, my lord, 32, I got personally in the afternoon.
30?
Next week, 32, my lord. The trial court work is there. Monday.
See, we can do one thing. Whosoever, if both the parties are there.
Yes.
If both the parties agree for an adjournment, you can take an adjournment date from the court officer.
May I request, my lord.
32
Both
Monday.
parties must be there.
Other side is state, my lord. Monday.
We don't know, but both the parties are there, that liberty possibly we can give, ma'am. If
May
the
I-
parties are appearing and they are there, they are making a joint request, we will. I'll just say that on joint request.
May I
Yeah,
request, my
there,
lord.
wherever interim order is there, you mention it, we will continue.
May I request, my lord. The present matter, we filed a counter and sought for a clarification also. My land fund complainant, my lord, not filed any rejoinder. Let them give their own calculation, my lord, how much he is entitled. That's the
Lord,
whole
we
my lord,
agree with
issue.
the calculation.
How much
Yes, we
they
agree
are
with the
liable to pay,
calculation
how much I have to
made in
liable to
person.
pay.
What do you say?
My lords, we agree with the calculation made in paragraph 4, my lords. It is the Raichur University which has to transfer. It is Raichur University which is in default because the transfer has not happened. And so my pension is not settled for more than 1.5 years. Grateful.
ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಅಂದ್ರೆ ಎಲ್ಲ ಆಗಸ್ಟ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳಿದ್ರೆ ಎಲ್ಲ ಆಗಸ್ಟ್
ಮೇಡಮ್ ಏನ್ ಹೇಳಿದ್ರು ಸಾಹೇಬ್ರು?
ಇಲ್ಲ
230.
Court officer, madam.
ಸರ್ ಹೇಳಿ ಸರ್ ಹೇಳಿ
Madam, Semar 42, needful has been done, madam. Adjournment ಕೇಳಬಹುದಾ ಅಥವಾ ಸಾಹೇಬ್ರ ಹತ್ರ ಇದ್ದಾಗಲೇ ಕೇಳಬೇಕಾ?
ಸರಿ.
ನೀಡ್ಫುಲ್ ಡನ್ ಮಾಡಿದೀರಾ
ಒಕ್ಕಲದಾಕೆ.
ಸರ್
ಹಾ,
ನೋಟ್
ಮಾಡಿದ್ದೀನಿ ಮ್ಯಾಮ್. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇತ್ತು
ಸರ್
ಮ್ಯಾಮ್.
ನೋಟ್
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕಂಟಿನ್ಯೂ ಆಗಬೇಕಿತ್ತು ಮ್ಯಾಮ್. ಓಕೆ, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕಂಟಿನ್ಯೂ ಆಗಬೇಕು ಮ್ಯಾಮ್.
ಸರ್ ನೋಟ್
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್
ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ
ಕಂಟಿನ್ಯೂ ಆಗಬೇಕು ಮ್ಯಾಮ್.
ಓಕೆ ಸರ್
ಅಲ್ಲ, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಲ್ವಾ? ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್.
ಸರ್ ನೀವು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ಹಾ ಮ್ಯಾಮ್, ಹಾ ಮ್ಯಾಮ್.
ಸೊ ಅಪೋಸಿಟ್ ಯಾರು ಇಲ್ಲ?
ಯಾರು ಇಲ್ಲ ಮ್ಯಾಮ್ ಅದರಲ್ಲಿ. ಅಂದ್ರೆ ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕಾಗಿತ್ತು, ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದೀವಿ.
ಸರಿ ಸರ್ ಆಯ್ತು.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀರಲ್ಲ ಮ್ಯಾಮ್?
ಆಗುತ್ತೆ ಸರ್ ಆಗುತ್ತೆ.
ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್.
28 ನಿಮಗಿಲ್ಲ, ಹಾಗೆ ಇದೆ ಅದು ಎಲ್ಲ 30, 31 ಎಲ್ಲ ಇದೆ. 70 ನಾವು ಅದನ್ನೇ ಹುಡುಕ್ತಾ ಇದ್ದೀವಿ.
70 ಇದೆ ರೆಸ್ಪಾಂಡೆಂಟ್.
7 ಆಗಸ್ಟ್ ಅಪೋಸಿಟ್ ಇದ್ದೀರಾ? 17 ನಲ್ಲಿ ಯಾರು ಸರ್? TR ರಮೇಶ್. ಇದರಲ್ಲಿ ಸರ್
ಅದರಲ್ಲಿ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು ಮೇಡಮ್. ಕಾಮನ್ ಆರ್ಡರ್.
ಗವರ್ನಮೆಂಟ್ ಸರ್ ಒಂದು ನಿಮಿಷ. ಟ್ವೆಲ್ವ್ 8 ಸರ್, ಮೂರು.
ಆಯ್ತು. 29
ಸರ್ ಒಂದು ನಿಮಿಷ ಮೇಡಮ್, ಇದು ನಿಮಗೆ 30
31 70.
ಒಂದು ನಿಮಿಷ ಸರ್.
ಮಿಕ್ಕಿದ್ದು ಕೊಡಿಲ್ಲ. ಹಾಂ, ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಕೊಟ್ಬಿಡಿ ಸರ್, ಅದು ಫೈಲ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. ಸಾಕು. ಹಾಂ?
70, 30, 31, 70. Next. Maintainability. ಈ ಕಡೆ ನಾಗಭೂಷಣ್ ಯಾರಿಗೆ ಸರ್? ಅದೇ ಒಬ್ರು. Yes. ನಮಗೆ ಜುಲೈ ಎಂಡಿಗೆ, ಜುಲೈ ನಮಗಿಲ್ಲ ಸರ್, ಜುಲೈ ಕೊಡಕ್ಕೆ ನಮಗೆ ಇದಿಲ್ಲ. ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಹಾಕಿ ಜಾಯಿಂಟ್ ರಿಕ್ವೆಸ್ಟ್ ಫಾರ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಹಾಕಿ 10/7. $55 ಯಾರು ಇಲ್ಲ, ಗೌರ್ಮೆಂಟ್ ಬಿಟ್ಟು ಯಾರು ಇಲ್ಲ. ಅದು ಅವಾಗ ಆಗಸ್ಟ್ ಹೋಗುತ್ತೆ ಸರ್. ಒಂದೇ ನಿಮಿಷ ನಾನು ನೋಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತೀನಿ. 18/8 ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿ ಬರಬೇಕಲ್ಲ ಸರ್. ಸೊ ಮೇಡಮ್ 55 18/8.
ಕಂಟಿನ್ಯೂನಾ ಕ್ಲಾಸ್ ಇಲ್ಲೇ ಬಿಟ್ಟೋಗ
1 ವೀಕ್ ಇಲ್ಲ, ಆಗಸ್ಟ್ ಇಲ್ಲ, ವೇಟ್ ಮಾಡಿ. 69 ಯುಗ ನೀವು ಹೇಳಿದ್ರು ಅಷ್ಟೇ. 69 ಆಮೇಲೆ ಅವ್ರು ಬಂದು ಶೂರ್ ಜಾಯಿಂಟ್ ರಿಕ್ವೆಸ್ಟ್ ಅಂತಾನೆ ಹೌದು ಮೇಡಮ್ 69 ಬರ್ಕೊಳ್ಳಿ. ಬೋರ್ಡೇ ಇಲ್ಲ, ಜುಲೈ ಇಲ್ಲವೇ ಇಲ್ಲ. 11/8 ಜಾಯಿಂಟ್ ರಿಕ್ವೆಸ್ಟ್, ಎಲ್ಲ ಜಾಯಿಂಟ್ ರಿಕ್ವೆಸ್ಟ್. ಒಂದೇ ಒಂದು ಸೆಟ್ಲ್ಮೆಂಟ್, ಒಂದೇ ಒಂದು ಸೆಟ್ಲ್ಮೆಂಟ್ 42ಗೆ ಡೇಟ್ ಮೇಡಮ್, ಡೇಟ್ ಕೊಟ್ಟು ಮೇಡಮ್ 42ಗೆ ಡೇಟ್ ರೀಸಿಟ್ ಕೇಳಿದ್ರಲ್ಲ, 42ಗೆ ನಾನು ಅದು ನಿಮಗೆ ಕೊಡಲ್ಲ ಮೇಡಮ್, ಸುಮ್ಮನೆ ಇಟ್ಟಿರ್ತೀನಿ. ನೀಡ್ಫುಲ್ ಡನ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತೀನಿ, ನಿಮಗೆ ಕೊಡಲ್ಲ. ಬೇಡ ಬೇಡ, ನಿಮಗೆ ಕೊಡಲ್ಲ. ನೆಕ್ಸ್ಟ್ 42 ಕೊಡಿ. ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್
69 70 ತೆಗೆದಿದ್ದೀವಿ.
29 ತಗೊಳ್ಳಿ.
29
29 30 31
30 31 55.
Court officer, madam. Court officer, madam.
ಮೇಡಮ್ 42 ತಗೊಂಡ್ಬಿಡಿ. ನೀಡ್ಫುಲ್ ಡನ್, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೀಡ್ಫುಲ್ ಡನ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಅಂತ ಮಾಡಿ ಒಂದ್ಸಲ ವೆರಿಫೈ ಮಾಡ್ಕೊ.
Court officer, madam.
ಸರ್ ಒಂದ್ ನಿಮಿಷ 13/8 ಹಾಕೊಂಡ್ಬಿಡಿ. ಇಲ್ಲ, ಅದು ಮತ್ತೆ ವೆರಿಫೈ ಮಾಡ್ಕೊಂಡ್ರೆ ಮೇನ್ ಸೆಂಟರ್ಗೂ ಹೇಳ್ದೆ, ಅವ್ರದ್ದು ಮಿಸ್ಟೇಕ್. ನಾನು ಹೇಳ್ದೆ ಹಿಂಗ್ ಸರಿ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದೀನಿ ನಾನು. ಸರ್ ಹೇಳಿ
ಮೇಡಮ್, ಸೀರಿಯಲ್ ನಂಬರ್ 74 ಒಂದು ಅಡ್ಜರ್ಮೆಂಟ್ ಸಿಗ್ಬೋದಾ?
ಹೇಳಿ ಇನ್ನೊಂದ್ಸಲ.
ಸೀರಿಯಲ್ ನಂಬರ್ 74.
74.
ಹಾ ಮೇಡಮ್. ಕಂಟೆಂಪ್ಟ್ ಇದು ಐ ಆಮ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅಂಡ್ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ಕಂಪ್ಲೇನೆಂಟ್
ಅದಿಲ್ಲ.
ಗವರ್ಮೆಂಟ್ ಅಪೀಲ್
74 ಏನ್ ಸರ್?
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮೇಡಮ್, ಸಮ್ ಅದರ್ ಡೇಟ್.
ಯಾರಿಗ್ ನೀವು ರಾಘವೇಂದ್ರ ಗಾಯತ್ರಿ ಅವ್ರಗ?
ಹಾ ಹೌದು ಮೇಡಮ್.
ಗವರ್ಮೆಂಟ್ಗೆ ಒಂದ್ಸಲ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬಿಡಿ ಸರ್.
ಹಾ ಮಾಡ್ತೀನಿ ಮಾಡ್ತೀನಿ.
ಆಗಸ್ಟ್
ಡೇಟ್ ಮೇಡಮ್?
11/8.
ಒಬ್ಲೈಸ್. ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು. ಹೇಳ್ತೀನಿ ಮೇಡಮ್ ಗವರ್ಮೆಂಟ್.
ಸರ್ ತಮ್ಮ ಹೆಸರು?
ಶ್ರೀಧರ್ ಅಂತ ಮೇಡಮ್, ಶ್ರೀಧರ್ ಫಾರ್ ರಾಘವೇಂದ್ರ ಗಾಯತ್ರಿ ಸರ್.
ಇವರು ನಮ್ಮ ಶ್ರೀಧರ್ ಗಣಪತಿ. ಅವ್ರ ಹೆಸರು ಹಾಕಿ.
Lordship's kind leave, making a request for posting, my lord, a state appeal, my lord, where the land in question, my lord, was declared as a forest land by the authorities, my lord. The learned judge has now reversed the orders, my lord. Construction activity is going on there, some urgency, my lord. Monday, we request for Monday, my lord. Please, my lord.
See, my lord.
No, my lord, it is a fresh matter, my lord, fresh matter. The construction activity is going on, therefore there is some urgency.
Serial number 43, my lord, contempt matter. The order is complied, my lord. The contempt may be closed. Accept.
Serial number 28. Shri Nitin Ramesh.
Apologies, Lord. Pre-session, there was audio quality was subpar.
He's governed by the old pension scheme in the earlier.
I am governed by that.
In the new, it's a new pension scheme. What is being said is a direct.
Please.
Your case is, since it's through proper channel, it would be a continuity.
Please.
If it is a continuity, it will be old pensions.
Old pensions. Please.
Now, submission is the employer's contribution has not been paid. That's what?
Please.
Employee's contribution has come to installment monthly.
Please.
Not the employee's contribution. That's not your fault.
No. Yes, my lord.
For them to explain.
Please.
Why did you give it also?
Please.
Now, is it your case after you get that employer's contribution also, then the employee's contribution also in total, you will count that period which he had put in?
Yes.
There with them.
Please.
For the purpose of paying pension to him.
Yes, they've already stated as such. They've already stated as such in writing, in their objections that which they have filed. They've stated categorically that is 3, my lords, which is from where I superannuated. Bangalore. 2 was my previous employer.
Millard, I am appearing for 3. Millard, may I request Millard, annexure R5, page number 17 of my counter, please, Millard. That is page 17, last paragraph, Millard. The controller US GKVK Bangalore in note dated 3/7/24 has calculated the pensionary benefit.
This is
Millard,
17.
page number
page
17,
17.
Millard, my counter. After a lot of correspondence, this is Millard, we address a letter to the respond number 2. The controller US GKVK Bangalore noted dated 3/7/24 has calculated the pensionary benefit of Dr. S.N. Vasudevan for the total service he has rendered at UAS Raichur, that is from 1786 to 16/1/2018. The pensionary benefit calculate made as per the government order number dated so and so 8/12/67, Bangalore dated 29/6/87, and also in accordance with statute US Bangalore amended by notification date 31/12/98. Then, Millard, as per the above note, the entire pensionary benefit of Vasudevan rupees 1,23,912 rupees from 1/3/19 to 2000 commutation of pensions so and so so and so. Raichur has remitted just rupees. Please, Millard.
These who has to give now the balance amount?
Yes.
Raichur, Millard, is the calculation sheet. Next page, Millard, page 19. We have given a calculation also. How much they are liable to be deposited in my institution. Thereafter, Millard, I have to, Millard, they settle the pension. Now they say only 17.5% and plus.
We have R2. Yes.
You are R2 saying because he is governed by the new pension scheme.
We have given old pension itself.
You have given old.
Yes, ma'am.
Then why so much difference between pension and one?
My lord, there, your lordship kindly see, he worked from 86 to 2000 in the seats department, not in the university, my lord. Annexure R3, my lord. My he worked in our university 2009 to 18.
So this contribution is only from 9 to 18.
Yes, my lord. And regarding my lord, to 86 to 2000, your lordship kindly see the.
Where was he? 86 to 2000.
This is seats, this one. my lord.
Again, in a government company.
Government. man.
Government, Karnataka Seed Certification Agency.
My lord,
Your claim was for which period?
My lord, the entire, what is, may I just mention a few dates, my lord, so that there is no scope for confusion.
1 minute, my lord.
My lord, just. Originally, I started my employment with Karnataka State Seed Certification Agency. And from there, again, I took a technical resignation through proper channel. I went into UAS Dharwad, and UAS Raichur. Everywhere, the pension which I contributed from my previous employer, because it was only a technical resignation, continuity of service was there, it got transferred. So from seed, it has come to.
Seeds is a pensionable service.
Yes, my lord.
Yes, my lord, annexure, page 19, my lord, page 19 in the order, my lord, order of this honorable court, page 19. Para 10, my lord. From 86 to 2000, 90,000 they have paid, 12.5%. That is continued, my lord.
They gave you the amount. But what head was this amount? Was it a pensionable service?
Yes, my lord.
How do we get that?
That is himself.
86 to 2000 seed corporation is a pensionable service.
That is, he must explain.
At least, Rasma Fisher appears to be not, it's a corporation.
Yes, sir.
Well, on 7/7/2024, the agency, that is the seed certification agency, had remitted a sum of rupees 90,000 then as it prevailed towards its contribution at the rate of 12.5% along with 6% interest is something I mentioned in the writ petition. My lords, for pensionary benefits, my lords, I have put it as annexure A in my writ petition, my lords, but it's not part of the record here.
Can be permanent for transfer.
No, my lords, it is annexure A. Please.
90,000
Please.
for 86 for almost 14 years.
Please, up to 2,000.
Right, could be around 14 years.
Please.
So I have to satisfy that this was one, it was a pensionable service.
Please.
Or it can be any other contribution which has been made. If it is not a pensionable service,
Please.
it can be any contribution that was transferred to the new employer.
No, my lords, it's specifically mentioned as, my lords, I have it as annexure in the writ petition, my lords, perhaps that may not be part of the, yes.
This being a pensionable service.
Yes.
90,000 has been transferred to respondent number 2.
Please.
Respondent number 2, during which period you had worked cumulatively, that is seats.
Please.
Then 2,
Please.
and 1 to 3.
That calculation, I'm not aware what they have done, my lords, because the whole thing I have been continuously in service.
They say 2 has transferred 31 lakhs.
So this is the internal problem which is not.
Right, the breakup need to be given.
Please.
The breakup of 31 would include this 90,000.
Yes, my lord.
Include 90,000.
Yes, my lord.
Now what is your basis to calculate 1 crore?
Yes.
That is the old pension scheme, as per the employees from the beginning. At the end, as on today, those employees are in my institution, the same type of calculation I had given. Kindly take my counter. Please,
86.
From calculation sheet, the page number. Please, page number 19.
Yes.
As per the Honorable High Court order, respondent number 2 is directed to forward the entire pensionary benefit of the petitioner to respondent number 3 for further action within a period of 8 the date of receipt of the so and so. In this regard, respondent number 2 has sent 9,55,031 white check number so and so towards pensionary benefit and rupees 21,70,997 white check number so and so towards general provident fund. Regarding the payment of entire pensionary benefit payable to the petitioner include lump sum pension contribution, death cum retirement, statutory, gratuity. The total length of service they rendered. It is calculated as per the FD department calculation, total length of service. Then, my lord, what is the amount payable? Hence, total pensionary benefit of rupees 1 crore 23 lakh 19,112 pension as well as contribution has to be paid towards a pensionary as of now. Rupees 9,55,031 has remitted to ES Bangalore. Remaining rupees 1 crore 13 lakh 64,000 has remitted to take further action. So and so. Let they say in response to this calculation, my calculation is wrong. Therefore, my lord, 31 lakhs they remitted. Honestly, my lord, we have transferred to the complainant's account. Only, my lord, I have to pay 6 years, 3 months, what he has rendered in my institution. His appointment itself is, my lord, NPS, because he accepted the appointment order. Next annexure page, my lord. Please, my lord.
You cannot
Now,
re-agitate
I will
that.
continue. If it is only 31 lakhs is entitled, their calculation, I will continue same type of calculation. If it is a old pension scheme, as per the, my lord, the OPS, I have to pay the remaining 6.5 years. That is.
Please, my lord, in annexure A, if I may show, annexure A, may I just read that paragraph, my lords, which is reflecting what happened when I first joined the university from the seat certification agency. This is in paragraph, I had put this as very first annexure A in the writ court, my lords. In this connection, Dr. So-and-so and his previous employer have contributed rupees 90,150 by DD number so-and-so dated so-and-so drawn in favor of the comptroller UAS towards the pension contribution at 12.5% with penal rate of interest at 6% so-and-so. This is dated, my lords, 2001. My lords, it clearly says it was towards pension. My lords, beyond, my lords, because this annexure, which is a formal communication, refers to the DD also by which the payment was done. So my first employer has transferred 90,000 with the penal interest to the next the first university which I joined. The first university has made some error in the calculation in transferring for my 18 years service. So that is what my latest employer, that is from where I superannuated, has correctly said that about 1 crore something is pending for the 18 years of contribution. Now only part payment of 30 and odd lakh has been made, because of which my pension has not been settled for more than a year. This is where I'm caught in a quagmire, my lords.
Annexure R1, my lord, details I have given. The US Dharwad sent 1,87,920, my lord. Then the GPS 3. Yes. That is forward to the University Dharwad, my lord. From there, they have transferred to me, Dharwad University. Yes, my lord.
Lords, Dharwad itself got split. It got split into Raichur and Dharwad, and option was given with continuity of service. For some of them were allocated to Dharwad, some to Raichur. So there was no discontinuity at all. That is not my choice.
31/3
splitting of the
2009 is
university.
in Dharwad.
From Dharwad, Raichur to Bangalore. There has been continuity of service. That is the thing.
That I have calculated and here.
How did you treat that? Is it a pensioner? Is it as a pensionary under the pensionary?
That is transferred as a pensioner. We have forwarded to the university, my lord.
86 to 2000.
Well, that is by seed department. That's in the judgment itself it's mentioned.
Not in the court, possibly the person who is there will look into the pensionary contribution and they must apply their mind and then say so.
As per 66(4), my lord, the direction is like that only. As per the direction we have calculated.
Slight digression, my lord.
Their table is not accepted because that.
At least who is the officer at your, both of your officers must sit together and.
My calculation has been rejected. But my calculation they have rejected. It cannot be calculated in this fashion because if he, please, my lord, if he an employee, my lord, a teacher who appointed prior to 2006, my lord, 2006, my lord, the government came to the new pension scheme came to be introduced after the appointment by direct recruitment NPS. But in this present case, my lord, his initial appointment is 86 from Dharwad to Raichur, Raichur to Bangalore. 2018, my lord, 6.5 years he worked, he retired. Now, what calculation, my lord, what they are saying, my lord, this is only one, the NPS is made applicable. We have given a calculation. If an employee retired who appointed prior to 2006, this is the method of calculation we are paying the pension. Yes, yes.
Most likely that is that's the
OPS only.
OPS.
This calculation is OPS. My calculation is OPS. They are not agreeing.
Ours, ours also
The,
OPS,
the
my lord.
calculation of the Bangalore University is OPS, but the calculation most likely, my lords, I may hazard a guess. The calculation done by the University of Agriculture Science, Raichur, my previous employer, is on the basis of NPS. And that is why only the NPS part of the contribution they have transferred. Please.
No, 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 regarding that, my lord. 2009 to 18, my lord. No, no, regarding that, my lord, I filed the affidavit saying that we should OPS only. Yes, my lord. The endorsement is quashed, my lord. After that, we have treated as OPS and calculated.
31 lakhs.
Yes, my lord.
They say OPS.
They are saying new pension. No, my lord, it's not like that.
Old pension scheme, yours is also old pension scheme. Then on the basis you have to work out, and you have to work out the C corporation also.
Milord, that particulars, Milord, they must be having, because his appointment, Milord, is a NPS. Kindly, Milord, take the appointment order.
Saying OPS.
OPS.
It's not OPS.
Okay.
That's the reason we are saying your officers, accounts officers must sit together. Then decide.
Page number.
What happened here, something need to be done there.
Page number, Milord, 30, annexure R9.
Are you ready to sit together, your officer, both are?
Milord, they have rejected. Milord,
No, once again, you can sit.
if my land fund is accepted, their calculation is correct, Milord, I will continue for 6.5 years, Milord, whatever should be paid. For that, Milord, he has to furnish a PRAN number, permanent retirement account number. This was introduced by the government of India, Milord,
I'm
NDTPR.
so sorry, my lords, that permanent PRAN number is
then-
for those who are covered under the NPS. Government has made it very clear. PRAN number is only for NPS. Why? I don't have a PRAN number.
His appointment order, Milord, appointment order, he shall be governed by the new defined contributory pension scheme as per government order dated 31/3/2016. This is the appointment order. He accepted. For that, Milord, he has to give the PRAN number. Otherwise, Milord, I cannot transfer.
Please.
If it is, Milord, the same. My land. Please, Milord, if it is, Milord, OPS, not required. If it is a OPS, same method of calculation, Milord, I will calculate for 6.5 years, Milord, I will get it transferred to his bank account. In the absence of a PRAN
About
number.
bank account, my lords, they have to settle my pension for monthly pension.
Who has to settle
It's not
it
just
there?
giving me lump sum. I'm not entitled to any lump sum. I'm not even claiming a lump sum. I'm saying you get all the amount and monthly you pay my pension. That is all that I'm saying.
Milord, they are disputing the calculation of the Raichur University, Milord.
How can you put burden on?
Covers 86-2000 period also.
My lords, it says there has been continuity of service.
From 86.
My lords, it doesn't say anything. My contention was that I have been continuously in service. My very first annexure was that the amount has transferred from my first employer. Now, the issue arose because my second employer came in the way of treating it as OPS. So it was quashed, so which means that it reverted to OPS. So I have been in continuous service in OPS. Now, in the middle, most likely, my lords, my maximum service has been for 18 years with the University of Dharwad, come University of Raichur, which is the same. There, they have not done the calculation as required under OPS. This is where perhaps the flaw is.
May I submit, Milord? I had given, Milord, the calculation of the OPS. They are not agreeing. Let them, my land fund, file, Milord, what is his entitlement of calculation from
Very well.
that university and also my university, Milord, I am going to.
Seeds also.
Please, Milord.
If the officials are also
Milord,
directed
each
to
department.
sit at, please.
You should understand on what basis they have calculated
Yes.
31 lakh. On what basis it is calculated 1 crore.
I'll also try for a calculation.
Better then.
Accused 1, 1 and 2. Yes. 2 and 3. No, 1 and 2.
Through rejoinder, let him give a calculation.
Both of you file your objections?
Yes, my lord, we file.
Both have filed. Both have.
4/8.
Yes. Sometime in July, my lords. As for more than a year, his pension.
23/7.
Lords, may I make one request, lords? Can the officers of both the universities be directed to come up with a clear tabulation, because they're the response,
We have,
they won't be able to give.
they have given their calculation, my calculation, let them give
They
their
have
own
not given the
also given
calculation.
page.
They don't say
They
how
have
they
also-
arrived at 31 lakh.
Page 17, I give a clear calculation, how I arrived the amount.
You should sit together.
Yes, that's true.
Still out of you. This can't be done in the court.
That's true, man.
We can't even hear them on this. You have to, both of you must apply your mind and
Lords,
then come to a conclusion.
a direction, my lords, from this court just. Yes.
Let's say that, liberty shall be given. Respondent number 2 and 3. Through their accounts officer. To sit together and of the calculation of pension, contribution of the pension. Payable to the petitioner.
Great.
23/7.
Actually,
29 to 31. Seal number 32, Shri Amarnathan.
R1 had filed Wakalat on behalf of R3. They are compared to the R1. And R1 only stated registrar has written a letter to assistant registrar. Complaint is very serious. Go personally, verify and report. That's all. That cannot be a dash. Assistant registrar, what is the report is that is not certificate. That's not complaint. And more A2, A4, A5, they are not appeared from those service.
Post the compliance affidavit being filed, we have held an inquiry on 29/3/2025, my lords, and found out that the quorum was not there to amend the bylaws as such. Post the inquiry held on 29/3/2025. As on 10/6/2025, we have addressed a letter to the Secretary UVCE, who is under contempt in the present. I'll pass on a copy also. I'm serving, because the letter was addressed yesterday, I'm serving the copy now. So we have complied with the directions. We have found prima facie that quorum was not there to amend the bylaws. So why the bylaws were amended, we have written to the Secretary UVCE along with our inquiry report to state the stand, my lords. They are also contemnants before the court, but they are not appearing before my lordship. Accused number 5 is the Secretary UVCE, my lords. It's the Alumni Association, my lords. My lords, inquiry was prima facie was to be conducted by us, my lords. We did conduct the inquiry. So the main allegation is in the Alumni Association meeting, the quorum stipulated is 40% attendance for any amendment to the bylaws to be conducted. So an inquiry has to be done to find out whether the 40% attendance was there in the said meeting. So we did conduct the inquiry and found out that there was no 40% attendance required for the quorum, necessary quorum for the amendment of bylaws. So we have concluded the inquiry, and yesterday we have addressed a letter for the secretary to give his explanation with regard to the finding of the inquiry as such, my lords. We have given them 15 days time to reply to our said notice, my lords. The complainant is a member of the said alumni. So complainant complained about the irregularities in the alumni association. So we as the register of the said society, yes, there as per the complaint, there is irregularity.
Apart from that, my lord, in past 25 years without holding elections, my lord, Grand Assembly getting elections, they 20 members, the only group they are having function. And you check it up. I'll check it up. And other allegations were no, that is not only one. That are other allegations. No. Other confirmation was there. I'll check it up. And the direction is to.
Direction was the earlier reports were quashed as such, my lords. Then a liberty was given for the complainant herein to give a fresh representation. On a 2-page representation, we have done this much, my lords.
In accordance with the order of the Honorable Court in the and on perusal of the complaint of CBN Anand so and so, in view of the alleged serious irregularities against the alumni association, serious irregularities are there. 25 years they are not conducted the elections. All those things are there. Many other misuse of funds also is there. Serious allegations were there. That complaint was not at all entertained. Now the court directed to entertain. July, the registrar issues an order to assistant research to inquire, and now they are coming with this report. I'll inquire it and Monday.
Direction for inquiry everything.
Well, because
Page 13 of the impugned order, my lords, for a moment, my lords.
That's why we are reading.
The C column is the one. Respondent number 4 is at liberty to vent out his grievance by way of a representation to the state, if any, with regard to the functioning of the petitioner, and the state shall consider the same in accordance with law. Post the disposal of the petition, there was a representation given to us, my lords. On said representation, this inquiry was completed. Now we have annexed the inquiry for the Secretary UVCE Alumni Association to bring out his stand within 15 days from the date of receipt of the said notice. Very good, my lords. No, we have done our part, my lords. Now they want to peruse the inquiry report and they want to state.
Monday, I'll just get it. I know instructions of what has happened.
Post 15 days, my lords, because we are waiting for the reply also, my lords.
48, 33, say number 33.
I appeared for the complainant.
For the accused number 1.
I had applied for a sanction plan to put up a school building. Approval was granted, but I did not pay the requisite fee. They cancelled the sanction plan. In the meanwhile, I had put up construction. So therefore, I approached this honorable court that the construction is as per the bylaw and in accordance with the requisite regulation. So that may be considered. The court also says, since it is building has already come up, so long as it is in accordance with the bylaw, you consider it. But now they issue the endorsement, since you have already completed, put up the building, your request cannot be considered. That is directly contrary to the, kindly see the order, Mula, which is at page 36, page 15. Page 15.
Para 1, petitioner is the owner of 9 acre 21 guntas of land in survey number 1/1, 62 Chikra Devara Sarjapura Hobbli, Anekal. Desirous of running a school on the said property, petitioner approached the respondent authorities for necessary plan sanction and approval. Same was approved in the year 2018. Subsequent to the approval, demand notice was issued on 14/6/2019. However, the petitioner committed default in payment to the amount to the respondent. Instead, the petitioner went ahead constructing school building. After the respondents initiated action against it, it paid the amounts demanded in the year 2019 on 29/7/21. By that time, the approvals have been cancelled by the respondents. Agreed by the same, the present writ petition is filed. Then, my lord, para 3 may be seen, my lord. However, the petitioner is not intending to carry out any illegal activities on the property. If the petitioner requests permission to run a school on the said property, respondents are bound to permit the same. At the best, the manner in which building has to be constructed as per bylaws and the amounts to be paid by the petitioner after getting necessary approval can be demanded by the respondents. Learned counsel for the petitioner submits that the building has been constructed in accordance with law. If there is any violation, petitioner is willing to alter the same in accordance with law. He further submit that the petitioner is willing to pay the charges that is required to be paid to respond number 2 for getting necessary approval as on today after deducting the amounts already paid to the respondents. But no, plan was given, but I did not pay the requisite amount. So they cancelled it. Now, when I approached the court, I said that there was some mistake on my part in not paying the amount. I paid it belatedly. So building was constructed. I said that so long, if there is any violation, I'm prepared to alter the building also.
Lord, my instructions have, Lord, they themselves have filed my endorsement, the reply. Lord, may kindly see the operative portion of the order. Lord, the respondents, Lord, the page 17, Lord. The respondents are directed to accord necessary approvals to the petitioner in accordance with law to run an educational institution on the property which is a subject matter of the writ petition as expeditiously as possible. The respondent shall indicate the petitioner the amounts, if any, payable by it for running an educational institution on the property in accordance with law, and the petitioner shall pay the said amounts within time stipulated by the respondent. The writ petition stands disposed of. The only thing is that, my lord, he was supposed to construct it in accordance with law. And if any payments are to be demanded by us, my lord, he is supposed to pay. But what happens is, Lord, may kindly take my endorsement which they have produced along with an application,
affidavit.
Application. Lord, may permit me to read the page 6, my lord. The translated copy starts from page 11.
No, relevant is the last para, page 22.
Let's see that. Yes. I
8/4/2025. IA affidavit. ಅಲ್ಲ ಇದೆ ಸಿಕ್ಕಿದೆ.
Lord, common substances, we have said we asked for a permission from the state government earlier with regard to the payments. That was refused. It was communicated. Subsequently, now you are asking for a permission from us as though you. Yes. The peculiar situation is this. Yes. But he continued the construction. Yes.
It was COVID period. COVID period. Difficult.
COVID period, not only for the payment, for the construction, also the COVID period should apply. But that cannot be an excuse. Yes, but the fact what happens is, Lord, if I extend this benefit to one person, it gets extended to thousands.
Court order is there.
No, that is an issue, Lord.
They should have challenged it.
No, court has said in accordance with law. Court did not say that to go bypass the law. Please move.
Prior sanction before construction.
Yes. That's my lord, how even the endorsement speaks of. So the fact is that my lord, there's no via media which.
Post-construction sanction of plans.
Yes, even the Supreme Court has come down heavily on us, say, planning authorities for giving a post-construction
But here,
approval.
sanction is obtained. Sanction is obtained. Only mistake is I did not pay the amount. Thereafter on 21 they have cancelled it. This is not a case of. But plans were cancelled because of non-remitting of the fee. Actually, it should relate back to that particular date.
That is not the. Yes.
Actually sanctioned the plans.
Yes, it was. Yes.
All of non-payment of some charges.
Yes.
And based on that, he made a construction. Now the construction needs to be regularized. If they are safe, if they are in accordance with the bylaws. On payment of any charges which you may claim. Because it can't be without any charges, even the sanction plan need to presuppose a certain payment or certain.
Yes, yes.
That's how it should be.
We have paid that money also. If there is any additional amount also, we are ready to pay.
Then Lord,
And mind it, we don't know whether it will have any precedential.
this.
No one can construct without plans being sanctioned. In this case, maybe you were under the belief that you went ahead with the sanction plans, but they did not pay the fee.
Yes.
So, since the sanction plans have been sanctioned, the fee has not been paid, you cancel it.
But what?
So,
Here are two aspects, Lord. One is development plan, and another one is the construction plan. There are two aspects. One is the development plan. Then, Lord, from the local planning authority, they'll have to take, Lord, either if it falls within the BBMP limit, then they'll have to go to BBMP to take a building construction plan. Here, development plan is approved by the planning authority.
Here it is only beyond BBMP.
Yes. There are two aspects.
The
There will be two aspects already, always. It is also a development plan and construction plan.
That is not the reasoning given, my lord. He is going into some issue which is not there.
No, there will be two different plans. One is kind of by the same authority. If the BDA is the authority, both the authorities for the area. Here in Bangalore city, my lord, if it is inside the city, the BDA will be a planning authority which grants and its approval for development approval, and construction approval is given by the BBMP.
This is beyond BBMP limits. This is beyond BBMP limits. Only BDA is the authority.
Then I'll have only a. I'll be a planning authority.
That is all.
I'm a planning authority. What has happened is he's constructed the building already. Now coming for a plan approval of the layout. Then again, after receiving an approval from me, he'll have to go to concerned either panchayat or any other municipal corporation or any other corporation for town planning area for building construction. Here is total reversal. From that till here they are trying to come. That is what we have said. It's not permissible for us.
Non-residential educational development plan of the plan. Previous litigation, petition building construction.
Development plan was also approved by you.
Yes. Development plan is what is approved.
Development. Construction plan.
Construction plan, they are not the authority.
After the approvals and payment of all those things, then they'll have to take a construction plan.
Is there any construction?
They say there is a construction.
No, it is there in the order.
There is a construction.
Judgment itself notes all that. Judgment notes that I have gone ahead and put up construction.
And para 3, it specifically says that permission to be given to run the school. In fact, at para 1, they say petitioner went ahead constructing a school building. Now they are trying to go against this order itself. And after the respondent, in para 3, they say if the petitioner requests permission to run a school on the said property, respondents are bound to permit the same.
Lord, that is.
That is the one, my lord, which I have produced
Page
along.
6, my lord, page 6 of the said application, Lord. Page, translated page.
Translated copy, the
7.
last after narrating, my lord, last para is the, what is the only conclusion? Page 22 of that IA. That is the only reasoning. Having examined the matter again, as per the order of the Honorable High Court, building has already been constructed without obtaining prior approval. So at this stage, there is no provision.
Yes. In accordance with law is only the. May I make this submission? I, as a planning authority, I give a approval for the layout. In the sense, for the entire the.
No,
extent
there is
of the
no
land.
layout here,
No,
only a development
layout in
plan.
the sense develop. We call it in a technical term. It's called as a layout development plan. It's called as a layout.
Only
Then what
development.
happens is we say the building has to come up in such an area, in such a measurement, all these things, or with
Put it on
the
the
approval of required permissions from the other departments. You will have to then come with a sketch of.
All that had been done and you had approved it.
No, Lord, that was not done. That was not done. That was not done. That was not at all done. This is only a development plan in the sense only a leveler. No, that is what is the development fees that we collect. But thereafter, there is a building plan approval.
No, no, he's not concerned with that.
According to you, something is approved.
No, according to us, only the development plan is approved. Yes.
Authority to approve the layout. Okay.
Yes.
Whatever that was submitted to you was approved.
Yes.
Subject to payment.
Yes.
They did not do that.
And approvals. Subject to approvals. Yes.
It was approved.
Yes.
Whatever it is. I don't know about building or layout, etc. Something, whatever you say.
Yes.
Whatever
It's
that
a
was your command, that was approved by you.
Yes.
And later, they did not pay the amount.
Yes.
And therefore, you see, you have not paid the amount, therefore I cancel it.
Yes.
That's what you said.
Yes.
Now they have come up with the contention, which was upheld by the single judge. That, see, now they have come. Examine whether they have constructed as per your detailed approved plan.
No, there has to be a building plan approval.
No, building plan is separate and I have taken from Panchayat authorities. I don't know how you may learn it from this concern with that.
Now what Now what are they trying to say is, since I have constructed, you permit me, give me a plan approval for the development plan. Correct. One person who doesn't even takes a building plan approval, then constructs it, then comes and says, you approve post facto. This is not permissible.
I'm sorry, my lord, it's factually incorrect. So far as construction plan, I have taken it from Panchayat. He has nothing to do with that. He is raising some contention which is not raised before the learned single judge.
Two different aspects.
Development plan, my lord, what BDA gives. In fact, the construction plan, Panchayat is the authority which I have taken it separately. He has nothing to do with that. He is only concerned with development plan under Karnataka Town and Country Planning Act. What should be taken under the Panchayat Raj Act is entirely different.
Right.
Now the development plan.
Yes.
Post facto approval need to be given. Post facto. You will approve the plan of the development plan.
Yes.
You will withdraw the cancellation.
Yes.
It's like this development plan which at least understood everything would be given, the street lighting, the road.
Yes.
And that you have approved, they did not pay the fee, you cancel it. But there is another aspect also of the construction to be made on the plan, development plan.
Yes,
individual
on the land, yes.
Dwelling units, anything.
Yes.
That according to him is to be done by the
Panchayat.
panchayat. Subject to what you say on that.
Yes.
Be that as it may. Now, if you have to approve a development plan, insofar you are concerned, construction is inconsequential. You are not concerned with construction. You are concerned with the development plan. Okay? Construction is, according to him, is the subject matter before the issue for the panchayat to look into. So if that be so, you have to see what were the plans you had approved. In what manner they have created those, their development has been carried out. Is in terms of your plan, which you had earlier approved, later cancelled. If you say yes, you will say, look here, very well, you have done it, you have made constructions of the dwelling units, but since this is as per plan which I had approved, which later cancelled, can't you approve it? Subject to whatever imposition of fee, penalty, anything, what you have to incur, or what you have to impose.
Those section 9,
That can be done now, Mr. Chairman.
as per the instructions, my lord, as per section 15 and 17 of the Town and Country Planning Act, we don't have that power of post facto approvals.
Then why did you challenge it?
Lord, Lakshmi, give me 3-4 days time, Lord. I'll take instructions on this as to whether even the construction building construction plan, whether the BDA itself is an authority or not, or I'll
He is
take
not
that
the
also
authority.
instruction.
He is not the authority, is well known, my lord. So far as the lands is concerned within BBMP, construction plan by BBMP, development plan by BDA. So far as lands which fall outside BBMP, it is either the local authorities plans, construction plan, and development plan is by them. That is panchayat. No, but all construction will have to be in accordance with the zonal regulations of the BDA. What we say is ultimately, my lord, it is zonal regulations which are paramount. Now, suppose I have made construction contrary to the zonal regulation, nobody can regularize it. But not taking the plan and the payment of the fee, these are all procedural matters. Ultimately, that is why I said before the court that if it is my building is not in accordance with, I will alter the building also if it is required. That statement also I have made. Now, what is argued now by learned friend is trying to re-argue the matter. Otherwise, my lord, why should I come to the court? It is as good as losing the case. Now, learned single judge, I went to the court only for this purpose. Now, he is trying to overcome the order of the learned single judge itself.
Lakshmi, grant me. I did not challenge. Lakshmi, grant me a week's time, Lord. I'll take for.
It says in accordance with law.
Yes.
To see in the direction.
No, that para 5, Lord, it indicates.
Necessary
No,
approvals in accordance with law to run education institution on the property.
Yes.
So means whatever development plans you had earlier approved, later cancelled, the development plan now on the surface is in accordance with those plans. In accordance with law is only this now. When the plans are in accordance with law.
And actually, the respondents are directed to accord necessary approvals to the petitioner in accordance with law.
Yes.
Law means not your payment of fee.
Not only payment of fee, Lord, it includes several other things.
It is not that post facto. It is post facto only. The order itself says that you have to do the post facto.
Yes.
And you now come and say in a
I'll seek further.
post facto is not law.
I'll
You didn't agree that.
I'll seek for further instructions.
Law is, it is in terms of bylaws. This is the fee. In the peculiar fact, we don't know whether you have regulations to carry, to claim the fee, the charges in the bank. But you have to evolve some
mechanism,
methodology to in these circumstances what is the way.
Yes.
But that doesn't mean that in accordance with law is previously he had not taken the approval. I have cancelled it. Now I can't look into it because any development plan approval of any approval of plans prior approval should be there. That you can't pay for.
Unless either I should challenge or not, I should even come back. Yes. Lordship may grant me some time.
Somebody has interpreted it in a very, very unsatisfactory way. Only I can.
Yes, yes, I understand.
Except the fact your apprehension that people will start making construction and then say, approve the plan, this is in accordance with bylaw. That can be a very valid objection. But in the facts, in view of the direction to accord approval, who is not challenging it, can't do it. In accordance with law is bylaws and what are the charges you have to claim. Okay.
Please.
ಸ್ವಲ್ಪ ತರಿಸಿ ಅದೆಲ್ಲ ಡಾಕ್
5-8.
Oblige.
Serial number 34.
Cost was imposed on the government. Please. Please.
48.
But could it be, my lord, earlier? So. Yes, my lord.
Once you got it, the interest stops. Only 25,000.
Retired teacher, my lord.
No prejudice. Next.
36, serial number 36, T N Vishwanath. Fourteen eight, serial number 37.
Contesting respondent, as the matter pertains to bringing the legal representatives on record in the writ petition, which was allowed. And what has happened is the interim order was obtained. Though my caveat was there, it was suppressed, it was not shown, the name was not shown. And on that moment, my lord, the interim order has been obtained. Not to precipitate the inquiry proceedings have to go on as per law, my lord. Not charge, my lord. This is regarding the coming under the purview of the Hindu temples, my lord, which is Muzarai temple for temple archaks post. Direction has been issued by the single judge, my lord, to hold inquiry and finish the inquiry by including even the petitioner before the inquiry as a party. My lord, in the meanwhile, the interim order has been obtained. The whole proceedings is stayed now. Been stayed since a long time, and I had filed caveat. Could have been heard, my lord. Copies could have been served. Name itself was not shown. My grievance is it should have been. And consistently they have been absent in the order sheet. It is. Is filed, is it for vacating? Objections are filed, my lord, by us. If the interim order is not extended, they'll come, we can argue the matter. Even tomorrow we are ready. Short point is involved. They have to find out who is the person who is now, as per the Hindu Religious Charitable Endowments Amendment Act, who is the person who is entitled to carry out the pujas, main archaks. The endowment commissioner will hold an inquiry.
They are claiming on being an hereditary.
They are claiming as hereditary, but they were not through the person who was archak is our contention. Admittedly, that's the contention.
You are doing now the.
No, my lord, I'm unable to.
Precipitative action.
Precipitative action, as far as it should have been restricted to the, but it has reached the temple also. The temple also, they say, interpretation is there is a stay order, you have no right to it.
Who is doing it?
They are doing it.
87.
Yes.
38.
Appearing to the appellant's my lords, the address that we issued the notice to was the same address provided in the writ petition, my lords, wherein the respondents have appeared, my lords. But in the writ petition, my lords, the writ appeal.
They are not appearing here.
Please, my lords, my lords, they permit us to serve the notice on the counsel who appeared in the writ petition, my lords. The same counsel appearing for the trial court matter as well, my lords.
Serve the parties. He may have instruction, he may not have instruction. Without instruction, he can't appear. Next.
11-8, C number 39. Srivachan.
Represent the counsel for the respondent and the complainant in the contempt petition. Both are taken up together.
Lords, we have served the copy of the appeal memo on the respondent's counsel. We had not filed
My
the.
lords, in my respectful submission, prima facie it is an abuse of process of law for the simple reason that when we filed the contempt petition and when specific orders were passed for compliance, they wait for almost 1.5 years. I don't know how the registry has calculated the number of days delay as 121, in which case I will not be able to oppose it. But the very factual foundation of determination of the delay, 121 in my respectful submission, I may have to concede, but it is not 121 days. My lords will see the date of the order which they have taken up. Almost after 1.5 years, they are before this honorable court. And the question involved in this case is about when the site gets acquired by the Bangalore Development Authority. May I just summarize it?
I set up my facts, my lord. I set up my facts. I only made the submission.
When the site gets acquired, a small dimension site gets acquired by the Bangalore Development Authority 25 years back, and in lieu of and no compensation gets paid, in lieu of that by following series of orders passed by this division bench of this honorable court, a site was ordered to be allotted in favor of the allottee. Then the allotment took place. The order by which the BDA was directed to allot the site was questioned by the BDA, which I call it as a substantive order. And that substantive order was confirmed by the division bench of this honorable court. Now BDA determines the cital value without reference to the directions issued by the learned single judge and fixes the value at a rate which is as if I have to buy today in the open market, today's current market, current allotment value. Then I prefer a writ petition before the learned single judge. The learned single judge deals with every aspect of the matter, all contentions, and the operative portion order is that what the petitioner or the complainant was well advised to take the site and fight the litigation. Rather, yes, my lord, absolute sale deed is executed, admittedly. Absolute sale deed is executed. BDA without any, of course, with an observation, say the subject to the outcome of the writ petition.
What was the basis of the order for allotting your site? Was it a judicial order?
Yes, my lord. Yes, my lord. Yes, my lord. Junjamma's case, which the learned single judge deals with in detail, how the allotment was by virtue of the admitted position is that the site belonging to the petitioner was taken for formation of Vishweshwaraya layout. No compensation was paid. Subject to observing certain procedures, I was entitled for allotment of an alternative site. And then I come fourth round of litigation, if I'm very accurate on that. An order is passed by the learned single judge of this honorable court, allot the cital value, allot the site.
Does that order refers to any, what should be the value of the land? On what basis, when exactly the.
Yes, I will read that. I will. Yes, it refers to it, and then of course, even without reference to that, I was driven to a separate set of litigation on that aspect of the matter. May I just draw my
prevailing
on that?
Yes, my lords, the judgment of this honorable court in division bench upheld the acquisition. In the learned single judge quashed the acquisition. Division bench of this honorable court upheld the acquisition in Junjamma's case. In upholding the acquisition, certain protections were given to certain set of people. One among them are existing revenue site owners. The honorable court directed the BDA that within a certain period of time, the revenue site owners shall register themselves with the BDA, and these site owners shall get priority of allotment either in the same layout or in a subsequent layout at the prevailing market price. I'll just place the judgment for your lordship's consideration. In this case, my lord, they have deposited the money, sale deed has been executed. At the time of depositing, they did not deposit it without prejudice to the rights. Then I'll come to that, my lord. On a principle of law, May I request your lordships to kindly come to print page 684, my lords.
Page
684. May I read the operative portion of the order, my lords? The last three lines. The order, the challenge to the acquisition in all these writ petitions fails and is accordingly rejected. The acquisition is upheld subject to the following conditions. The petitioners in so and so petitions who are all owners of sites in question which are acquired are entitled to the following. These petitioners shall register themselves as applicants for allotment under the BDA allotment rules within a period of 2 months from today, extended by another month by BDA. If sufficient cause is shown, petitioners will have to pay only the registration fee. They need not pay initial deposit as the sites have been acquired and they are not entitled to receive compensation in regard to the sites under this arrangement. The petitioner shall file applications for allotment of sites to BDA within 3 months from today in the prescribed form, stating that they are applicants who are the petitioners in these petitions. The petitioner shall file the documents with BDA along with application to verify the same. Now this para is important. BDA will treat them as applicants entitled to priority in allotment and allot each of them a site measuring 30-40 in Vishweshwaraya layout or in any other nearby layouts in Bangalore at the prevailing allotment prices, subject to petitioners satisfying the twin requirements of allotment rules. My lord, the twin requirements are, one is that they have to be a resident of Bangalore for a period of 10 years. Second is that they should not have any other site, I'm sorry, my lord, Karnataka, any other site either allotted by the BDA or any other housing board society or so on and so forth. Now, my lord, so the two issues, my lord, that was relevant was that they have to first register themselves within BDA with a period of 2 months, my lord, which came to be extended until 2014. And my lord, the allotment, my lords, was to be in the same layout or any other layout at the prevailing market price. Now, the bone of contention is what should be the prevailing allotment price, not the market, prevailing allotment price. My respectful submission is, my lord, that what we have done is, my lord, consistently as and when, my lord, the allotment dates have varied, the cital values have accordingly varied as on the price as on that date, and the allotment prices have been fixed. And we have allotted sites at that prevailing prices. Now, my lord, the contention is that the contention of the petitioner before the learned single judge was, you could not take the price as on the date of the allotment. You'll have to take the price from me as on the date on which I either made a representation or you've taken the land from me. The various contentions. This is the bone of contention, my lord. My respectful submission is that the phrase prevailing allotment price cannot mean the date on which, my lord, I either complete the acquisition or they come before the BDA and seek by way of a representation an alternate site for the purposes of having lost the land. The reason being this, my lord, if in this judgment, if the Honorable Court had said that the allotment price shall be the allotment price as is being given today for the rest of the allottees in the same layout, then it. But the learned judges say that prevailing allotment price in this layout or some other layout. Some other layout would obviously mean somewhere in future. The allotment prices in future would be the allotment prices fixed at that particular time as and when that allotment is made. Therefore, my lord, this paragraph, my lord, is sought to be interpreted to mean that, my lords, that I cannot go beyond the price which I have fixed for allotment way back when I have done in the year 2003-4, my lord. That is when I made the allotment for Vishweshwaraya layout. Please,
for various reasons, you do not allot for 10 years.
Please. My lord, allotment is.
After 10 years, he uses the land here. Now, after 10 years, he will have to pay the then price.
My lord's allotment. Please, my lords, I'll answer it.
For the acquisition which has been made now.
Please, my lords.
He paid the amount, the prevailing right, that too maybe several years earlier when you made the forward notification.
Please, my lord.
Maybe another 10 years back.
Please.
That is how it works out. Under BDA, that is how it works out. 10 years back, you made the forward.
Please.
You are now and paid the price of 10 years back for the acquisition. And after 10 years, you allot, ask him to pay the value of 10 years future.
My lord's allotment, my lord's. My lord's direction was given in the year 2005, my lords. I'm sorry, the date of disposal of the order, my lord, is 39/2004. Lord, the cost here, my lord, we received a direction from the state, my lord, under section 65 of the act, asking us to increase the prices, my lord. So I have produced it, it's also a matter of record. Now, in the 2021, my lords, in which year we allotted the price. By then, my lord, the prices were revised. May I submit this, my lords? I understand what is being asked of me.
Allotment letter ಕೊಡ್ರಿ ಇದೆಲ್ಲ ಬರೆದು ಇಟ್ಕೊಂಡಿರ್ಬೇಕು allotment letter.
Please, my lords.
Are there any plots available in that layout? That's right. Could not have delayed it. Available.
Allotment letter ಕೊಡ್ರಿ.
My lords, what happens, my lord, is this. The general allotments were made in 2005-6, my lords. That is for an extent of the land that was available, my lords. At the time of acquisition, my lords, certain extents of land, my lords, are held up in acquisition or either held up in civil litigation or where the stay order I am unable to take possession. Over a period of time, my lords, certain other lands become available for development, and then over a period of time, my lords, in the very layout, in the very same layout, we have allotted site to him in the very same layout. But my lord, these sites, it is not a case of the petitioner, my lord, that this site was available for allotment to be made to him as on 2005. I delayed the allotment for a period of 16 years. Now I am asking unfairly a price in the year 2021, which ought to have been given in 2005. Please, my lord.
Commensurating the entitlement. That's right. Okay. And asset, this resulted in the delay. Whenever the first plot became available, as per his entitlement, I offered him, I am calculating on that.
My lords, what the petitioner here has done is, he has registered himself seeking allotment in the year 2019.
Not earlier.
Not earlier. He gives representations, but the division bench judgment says, in the prescribed form, go ahead and register yourself with the BD under the allotment regulations, my lord. Any person seeking allotment is required to register himself under the BD allotment rules. The division bench, no, my lord, they have not been varied. I'm sorry, single bench, they have not been varied.
I was not a party to that, but the inter se part, the judgment of the learned single judge at page number 91. This aspect has been gone into between the two parties, between the same parties. They took up in writ appeal. The Junjamma case, whether it is applicable or not, whether I am registered or not, that question was at page number 91 in a separate writ petition filed by me. And the BDA took the very same contention. Learned single judge rejected these contentions. BDA took it up in writ appeal. My lord, may I submit, my lord, 21 lakhs money.
I'll stand corrected, my lords. It's a single bench judgment, my lord, of Junjamma's case. I'm sorry, I stand corrected. The right of the petitioner does not flow either under the allotment rules or any other contract, my lords, that I have entered into with him. It necessarily flows from this judgment, my lord. It is not, my lords, their case that they are entitled for allotment under the allotment rules, that they had made a formal application under Rule 5, registered themselves, and they're by virtue of seniority they are entitled for allotment. No, my lords. Their case is that they had a site which is a revenue site in the Vishweshwara layout, which was acquired by the BDA for the formation of Vishweshwara layout, which by pursuant to this judgment, now they are entitled for an allotment. So they necessarily, my lord, if they are seeking a right under this judgment, my lord, the directions issued under the judgment bind them, my lord, as much as it binds me.
Well, that's one respect. I owe a clarification to the honorable court on this aspect. Junjamma was read and then it was slowed down. Kindly see page number 91 at annexure M. All 21 lakhs I have paid for obtaining the sale deed. Even though the case laws are in my favor, cited, the judgments were cited before the learned single judge, and I am seeking refund of the amount which came to be ordered by the learned single judge, which is under challenge in this belated writ appeal, which I am saying that that order is dated 19th June 2000. Not yet. We have put the compound wall. The construction has not happened yet. No. I will obtain instructions in case.
When they make the payment, my lord, they don't do it
after
without
having
prejudice.
executed the sale deed. After.
Please.
The number of delays is not as it is put in the cast title. The number of delay. No, it's plenty, my lord. 19th June, my lord would see 19th June 2023 order.
How much is the delay according to you?
I have to, it's 17 months. 17 months. That's why kindly have it next week. We will assist the honorable court. Otherwise, my lord, we waiting in this process. I will, if the number of days is exactly the same as the register is calculated, I will concede, my lords. On Monday, I will concede. I will not, my lord, it is prima facie. Kindly see the order which is under challenge at page number 15.
I'm sorry, my lord, may I say this? It does not look to be 123 days. It definitely is more than that. I do not know how, my lord, even I seem to have made a mistake. I'll look into it, my lords. I'll look into it. It does not look to be 123 days. It does not seem to be 123 days.
Kindly have it on Monday, my lords. We will.
Not Monday, we give you a date. Just
11/8.
next.
Obligation.
40, serial number 40.
Great for the review of the process. All intelligent. That we argued here that this matter is of northern magnitude issue. Other issues also of northern and involved in petition. The matter related to the Bhudana movement of the concept outside of Babedi. Then we have 5 years back.
No, not, it's coming up for the first time. It came up on 6/8/2024 because the law adjourned at the request of the petitioner's counsel. Then it came up on 29/8. And it's coming up today.
Prayer is the last of the kindly took it the last page number. 7 pages are there. Yes. My humble submission, lordship, is that keeping this question raised in the office of the detailed petition, keeping abeyance issue, notice my kindly order to the what is the issue of maintenance? Issue maintenance, I question the validity of the learned single judge order possibly by the respondent number 1, who obtained that order by playing a fraud on the court by suppressing the true material facts. And that judgment was challenged by the state government for the vision has confirmed the single judge order. Right. Page 150. State petition. In that, prayer number 3. May I read lordship? To issue writ of certiorari backing the order dated 30/6/2021 of this honorable court, passed with other single judge while annexed case, passed with petition number 55344 of 2017, connected with petition number 3848 of 2021, as a nullity and non-issue in the list of law, obtained with respondent number 8, trust by playing fraud and misrepresentation, also the guilty of suppression of value and suppression of policy in the light of the principle laid down by the Honorable Apex Court in Ramachandra Singh versus Savitri Devi, 2003 SCC, and in A.V. Papaya Shakti with the government of Andhra Pradesh. Though not amenable to any point of Karnataka Land Reforms Act under 1974 under Section 107 said Act, being the Bhudana land under the Karnataka Bhudana Act 1963 and under the Karnataka Bhudana Repeal Act 1982, having been vested with the state government, became the government lands, public largest property.
The prayer 3 is same in a recipe. Prayer 3 in a recipe. If my lord could grant me some time and get the particular.
Which one? Which one?
Prayer 3.
Prayer 3.
And that appeal is seized by this honorable.
Which appeal you are referring to?
The prayer 3.
Prayer C. 3, yeah.
Against which an appeal has been filed.
Against this 55344. There is an appeal pending.
No, appeal is not fit.
My lord,
When
my
this was
lord, with regard to the same matter, my lord, there is a writ appeal pending. My lord may.
Wait, look into that.
Yes, yes, my lord may have it on Tuesday and make it.
At the request of counsel for the.
Not issued, my lord. Please kindly have it on custody. I'm going out of station to Hyderabad.
Pardon?
Kindly have it on Friday, next week Friday.
No, we'll just give you a date.
What?
At the request of counsel for the AGA for the respondent state. Not to take instruction, we will give it in July.
Sixteen, 7. 41, serial number 41.
What is this?
My lordship's order dated 12/3/25 may be looked into, my lords. They had to get the order modified of the coordinate bench of the learned single judge as such, my lords.
Forty-one, serial number 41.
Just one minute. At the request of counsel for the respondents. He's appearing online.
No, he has to get the order modified, my lords.
Where is he?
Serial number 41, Shri Rupesh. Five, 8. Forty-four, serial number 44.
Waiting for affinity.
Yes.
12, 8. 45.
We appear for complainant in this case, my lord. Raise time to for statement of objections. Raise time to for statement of objections to the complaints report filed by the respondent number 3, 4, and 7, my lord. His objections are ready, my lord, yet to be finalized, and I will file in the office, my lord.
The order is complied. For
Order
that
is
you have
not
to file
complied, my
objection.
lord. Order is not complied. Time, my lord. I will rest. I will time, my lord. To file statement of objections.
We filed compliance affidavit, my lord. Here.
2 weeks time.
Five, 8.
Obliged.
46, serial number 46.
Yes, sir.
Six, 8. 47, serial number 47.
Yes. Earlier reply.
No, my lords, A2 has to file the reply.
My lords, I appear for the complainant, my lords.
You are appearing for whom?
For the complainant, my lords.
Who has to file the reply?
My lords, the accused number 2, that's the dean of the institution.
Dean of the medical school has to file the reply as such.
Respondent.
Accused number 2 in the present.
Please, sir.
So representative.
My lords, Wakalat's been filed, my lords.
A2. In the interest of justice, granting time to A2 to file compliance report.
6, 8. 48.
Okay, for the accused, my lord, the representation, my lord, is already being considered. Lords, kindly see annexure C in the page 22, my lord, it's already been considered, my lord.
The single judge's, learned single judge's order, my lord, is to consider the representation, my lord, at page 17. They have only affixed, my lord. They have only, I've replied to their representation, my lord. They have only annexed the. Yes, my lord, we have replied when we passed. To the representation.
Which page?
My lord, may I request, my lord, page 24, my lord. Lord, there are two petitioners, my lord. Page 22 is one petitioner, my lord. 24 is another petitioner. My lord, we have not.
So yes, what do you say? We are next. Consideration of each heading.
Request, my lord.
Yes, because he states that the order has been applied with in terms of orders dated 25 to 25. Annexed by the petitioners along with the petition at pages 22 to
5.
5.
Obliged.
Seeks time to take instructions.
Obliged.
48, 49, Sharad Gowda.
I have filed my wakalat my lords for A1.
For
It's been
complaint.
shown that A2 is not served, my lords. I'll take notice for A2 as well, my lords.
So you give
A2 as well, my lords. Please. My lords, kindly grant me some time, my lords. Please. Grateful.
6, 8, 50, still number 50.
About the complainant. The order is not complained.
My lord? No, my lord.
Yes.
Order is not complained. It's relevant page 21, man. Relevant page 21, man. The order of this honorable court has not been complied with.
Yesterday, we have filed the online compliance affidavit. Physical copy is also ready, my lords. My lords, the order is only to consider the representation. There is no positive direction. The order is a one-para order wherein they have said to consider the representation is with regard to payment of dues for the supplies done during the COVID period. So what's happened is there has been COVID irregularities as such, my lords. So there was a commission appointed to look into the said supplies made during the COVID period as such. First, we wrote to the commission appraising them that there is a bill pending which we have to consider as per the directions of the Honorable Court. Second, a pre-audit was ordered to be undertaken in respect of the supplies executed by the complainant herein. Post the pre-audit, with regard to the first reference also on 15/5/2025, we have sort of served to the complainant herein, intimating with regard to our reference made. On 2/6/2025, the irregularities what was found in the pre-audit has been brought to the notice of the complainant and we have sought his explanation. As of today, we have not received any reply to the said communication sent to him.
We don't know minutes. We have not received any complaints. We look into it. A short date may can be.
Physical copy, if permitted, I'll file it, my lords. Online, we have very much, my lords.
58,
Grateful.
58,
Grateful.
51, Sri Ranganath. 51, 13/8, 52. Serial number 52, Shivardhaman Gunjak. 56. Serial number 56.
Appearing for the petitioner in this case. Please, my lord, with the liberty to file a fresh petition, my lord. My lord, my prayer is very limited, my lord. My prayer is to consider my representation, my lord. This is regarding the tender, my lord. Please, my lord, with the liberty to file a fresh petition with a different prayer, my lord.
Here also filed. Here also filed. So we made that. The learned counsel for the petitioner has filed a removal of law stating that the respondent number 3 had issued an endorsement dated 25/2025. We seek to withdraw the petition only to challenge the endorsement dated 22/5/2025. In the said submission, the petition is dismissed as withdrawn.
Great.
57. Serial number 57.
We appear for respondent number 4, my lordship, in this case.
For respondent number 3, my lord, we have not been given the copy of that application which he said to have filed.
Amendment.
For
copy
amendment.
also is not carry out amendment also, my lord.
All right.
12/8.
Right?
Sorry?
12/8, sir.
12/8.
58. Serial number 58. Sri Dilip Kumar.
This is an appeal, and it's a judgment and decree in a recovery suit or the commercial appeal.
How would you answer the delay? We are in commercial appeal.
Yes, ma'am. I've produced the medical record of the, along with the application, it has been filed.
Let's see that. Let's see the grounds for delay.
Malad, in this case, Malad, is a simple suit for recovery, saying that the construction material was supplied.
You have to pay 45. That's all.
Malad,
See the medical certificate. He required 3 days, and the period is 9/10/23 to 8/11/23.
the past was not there. He is in continuous treatment, Malad, that is why.
Where are the documents? Where is the other?
I may be permitted to produce.
The scope is very less for condoning the delay. Very
Malad,
narrow.
since it is the first appeal, Malad,
We are in a commercial.
kindly notice may be issued to the, I will furnish the document, Malad.
And an additional affidavit.
Yes, sir.
Counsel for the applicant seeks an how much time?
Yeah, 10 days time may be required. 10 days time.
2 weeks to file additional affidavit, explain the delay of high copy.
Yes, sir.
37. 59. Sri Muhammad Sharif. 59.
Yeah, I request for a short passover. I'm being led by Senior Counsel Mr. Dhyan Chinappa. May be had on the 16th or 17th. May be had on the 16th or 17th.
Both are connected, ma'am.
Both are
Yes, ma'am.
connected.
59 and
29 July? Where?
I apologize.
Illidu. In fact, there is one appeal that we had filed. 29th, your lordships have posted it. 29th.
That's on 29th of July. I have some urgency in this matter because
I
an
don't want to say
arbitration
anything
has
more.
been
I'll leave it
stalled
at that. I don't want to say anything. It's all right. Well, it's all right.
16th or 17th of June. 17th. Obliged.
17,
Obliged.
17, great.
17(6). 61.
Appearing for petitioner, we have informed the other side. It may be taken up in the month of August, your lordship. Please, your lordship. Please, ma'am.
The 14(8). 62.
I appear for respondent 1 and 2.
Appearing for
my lord.
petitioner, my lord. I have already informed. 3 and 4. Kindly praying for short accommodation, my lord.
Seven, 8.
Much.
63. 63.
63. Lordship, I'm being led by Mrs. Dhyanchanapa. May it be had on the 17th. There's some urgency in this matter because there's a direction issued by the Supreme Court to dispose of the appeal by 30th of June. There's a
As I appear for the respondent, we have also filed cross objections in the same cross objections.
Yes, your lordship. Correct. I've come in appeal. I'm claiming that it's a suit for a breach of an agreement pursuant to, it's a brand licensing agreement essentially, brand licensing issue under a services agreement. So I had licensed certain brands to them under a services agreement. I terminated the agreement, and pursuant to that termination, I said that they cannot use my brand any further. They have continued to use the brand in breach of that, of the fact that I've terminated the agreement. I filed a suit seeking a declaration that the termination is IEEE. Yes, your lordship. Yes, your lordship.
Both.
They are the sub-licensee. I am the licensor of the licensee of the I'm the licensee of the trademark from a parent company. I have sub-licensed it to them.
The trademark is with a US entity. It is with a principal. Our stand is under the Trademarks Act. It is only the principal who can file a suit for infringement. And a licensor, there's a clear bar under section 53. That was not the ground. On the ground that it is also barred under the Maharashtra Public Trust Act. The ground of the Trademarks Act was not considered. So therefore, I've also filed a cross appeal.
On the Bombay. Your lordship, the simple argument is that this is not a case where I would require to go seek the permission of the charity commissioner. The simple reason being that the act only contemplates a scenario where issues regarding the trust, any dispute regarding the trust would have to be sought. In this scenario, I am basically a third party. I'm an individual person. I am claiming a breach of an agreement. I'm claiming that they are essentially continuing to use something despite me having terminated the agreement under which they have been licensed this brand. it's not related to the administration of the trust. I'm a completely unrelated party. There are judgments that actually cover this, Your Lordship. Maybe had on the 17th itself, Your Lordship. Your Lordship, there's a direction that's been given by the Supreme Court to dispose it off by 30th of June. Maybe permitted to pass the order along. June, Your Lordship. If it may be had on 17th, I'm being led by Mr. Chinnappa in this as well. Would it be possible to fix this at 2:30 for here?
My lords, the IA 1 of 25 had been disposed of by this honorable court on 15th of April. It is still showing on the cause list. 15th April. 15th April 2020. Please. Please. And my lords, we have also filed a cross appeal that is tagged along with it. Notice may have to be ordered.
I'm accepting.
We have served them advance copies. Please, my lords. Our ground is that the trademark issue had not been considered by the trial court. It had been urged. Please, we had raised two issues, that both on the Public Trust Act and also under the Trademark Act, both of these acts, the suit was barred. The ground on trademark, we had filed a 711 on trademark as well. Please, we had incorporated. The ground. That under section 53 of the Trademarks Act, it is only the registered proprietor of a trademark who can file a suit for infringement.
Yes, Your Lord.
It was rejected.
Obliged.
64. For the appellant, my lord.
Yes, sir.
For the appellant, my lord. The impugned orders at page 16, my lord. In a suit for recovery of money, the plaintiff is the proprietorship concerned represented by a sole proprietor. Now, by order dated 5th of February 2025, the commercial suit is dismissed on the ground that the description of the plaintiff under Order 30, Rule 10 is not sufficient. Please, but the name is mentioned, my lord. It is not that the...
Name first, then propriety concern later.
Please, there is a judgment, Justice Ravindran's judgment, which has been relied upon in the lower court, which says it is either this or that. I will just produce that citation, my lord, which says that it is at best a technical error and... Absolutely, my lord. May I just read Rule 10, my lord, for the... Rule 10, no?
You didn't try to amend the first title also.
My lord, this was based on a preliminary issue that was filed. There was...
When the preliminary issue is there,
Please, CPC. My lord, but the name, everything is. No, my lord, because I had complied with Order 30, Rule 10. May I just read out Order 30, Rule 10, my lord? It says in the name of the business. Please, my lord, I'll just read it. Any person carrying on business in a name or style other than his own name, or a Hindu undivided family carrying on business under any name may be sued in such name or style as if it were a firm name, and in so far as the nature of such case permits, all rules under this order shall apply accordingly. So I can, my lord? My lord, that qualification is not, but that qualification is not under this provision, Order 30, Rule 10. It says any person carrying on. Please, my lord, this is the objection raised by the defendant. Please, my lord, in para 3, if I may just read out, kindly see page 19. On appearance, the defendant filed a written statement denying the plaintiff government's in toto inter alia, contending in para 3 of the written statement that the suit is filed against the defendant in the name of the proprietary concern, which is not in accordance with the provisions of Order 30, Rule 10 of the CPC.
Can you file a fresh suit?
Lord, fresh suit, I may be barred by time.
We don't know. Other than limitation, suppose it's within limitation.
It is not, it will not be within, this is a suit of 2020, my lord.
Issue notice.
Great.
12/8/65. Seal number 65.
Yes.
For the appellant in this case, my lord. My lords, we pray for a short accommodation led by senior counsel in this matter.
Eleven eight. 66. 66.
Appear for respondent number 5, my lords. May request for short accommodation.
7/8/67.
Please.
11/8/68. 68.
No, no.
4/8.
11/8. 67. 11/8.
68. 4/8. 69 and 71. Shri Mukkanappa. 13/8/72. 13/8/73.
Respondent notes.
13/8.
So in 73, I appear for the respondent. The appeal has become infructuous, my lords, for the reason that subsequently there is an appointment made by the authorities. And they were unsuccessful, my lords, before the learned single judge.
Okay, next.
75. 18/8/76.
For the appellant minutes,
Yes.
there's an interim order already subsisting.
No, I have filed a vacating application, your lordships. I have some urgency. Because since from 2010, my.
It is my scheduled property, my lord, that they have got an order before the learned
since from 2010, in the year 1988, the appellant herein has sold this property in favor of
That is
some,
under challenge in a suit as well. My apologies.
has sold this property in favor of one Kollureya. From him, I have purchased this suit scheduled property in the year 2010. Thereafter, I filed an application for seeking for conversion of the land in question. When that application was pending for consideration, some third party files a complaint to the sitting MLA of that taluk. He being the member of Land Corporation Limited, he forwards that complaint to the chairman of that corporation. The chairman of that corporation directs the deputy commissioner not to consider the application till inquiry is conducted here. That endorsement, based on that, deputy commissioner issues as endorsement to me. Since there is a status quo order passed by the corporation, I am not in a position to consider your application. That endorsement I had challenged before the learned single judge, Your Lordship. When that writ petition was pending for consideration, the very same appellant herein files an application seeking for impleading application. That application was dismissed by the honorable single judge. He doesn't challenge just that order. By suppressing that, he files this appeal challenging the final order. In the final order, the honorable single judge has directed the deputy commissioner to consider the application and to pass orders on the conversion. That now he having no locus standi. The first sale deed is of the year 1988, Your Lordship. He has not challenged that my vendor's sale deed. I have purchased in the year 2010. That sale deed is not challenged now. He files this appeal by suppressing all these material facts. And
interim order to
and
continue.
the undertaking is given by the government advocate, Your Lordship. There is some mistake while giving that undertaking. A reference is made to some other cases. I think that is not relevant to the case in hand.
But they
That
will not
may
proceed, they will not proceed with the conversion is what the undertaking is.
Now, apart from that, they have referred to some orders. So let them verify that, because
37,
much okay.
Grateful.
77.
My lord, if it could be had a week after three. Grateful, please, my lord. Any date a week after 3/7, my lord. Some inconvenience.
10-7,
Grateful, my lord.
77,
For respond number
11-8, 78,
For the respondent 7 and 8. I appear for the respondent 7 and 8.
11-8, 79,
But prayer B, C, and D will not survive. Prayers, not in this petition. Prayers B, C, and D will not survive. Interim order, request for interim order will not survive. But only notice has to go to R6. R1 to 5 are represented not before my lords. B, C, and D. R6, R1 to 5 are already. A date may fix. Great.
5-8, seal number 80,
For the appellants in this matter, Your Honor. The date may be fixed, Your Honor.
6-8,
Right.
81, five eight, 82, Murugesh Charity,
My lord, I appear on behalf of the appellant BDA, my lord. The order of the learned single judge has been challenged. My lord, the writ petition was filed after a long.
I appear for the respondent number 2. Blood. My lord, for our reply, I seek an adjournment for our reply.
My lord,
The senior is gone, dropped off.
my lord, this is a matter where, my lord, after more than 20 years, my lord, acquisition has been challenged. And, my lord, earlier round of litigation, my lord,
There are caveat. One is,
But I'll take notice for respondent number 3, my lord, the society to whom this land is allotted now, my lord.
government. Two. Order. Lord, the entire acquisition is set aside, the allotment made in favor of the third respondent is
it's
set
also
aside.
been set aside.
Everything is set aside.
And now, my lord, what they
So
are
far as
doing
my
is,
land has been set aside.
my lord, now, my lord, subsequent to the order passed by the learned single judge now, my lord, now they are digging up the road. My lord, this has already been allotted. Earlier 2 rounds of litigation, my lord, it has been upheld by this honorable court, by the honorable division bench, and by the honorable Supreme Court also. My lord, they have lost in all the earlier proceedings, and in spite of that, again, my lord, they have initiated these proceedings. My lord, those.
So now what is this being done?
Lord,
What is this being done?
it's as of now it is vacant, my lord.
But there is some activities going on.
Lord, in respect of that, I will have to seek instructions, my lord. So, this question 2 weeks time.
My lord, we'll not have any objection for the time, but in the meanwhile, my lord, let them not do anything on that, my lord, because by the time 2 weeks, my lord, if the entire thing, if they dig up, demolish, my lord, then it'll be difficult for us.
Don't do anything. Don't do any activity.
Please.
Yes, my lord.
Yep.
Lord,
No precipitative.
Please.
Lord, not sure what to submit on that.
We'll give a short update. What do you want?
Lord, to any date after 22nd.
Lord, I have filed a writ appeal against the same order, my lord. WA 633 of 25. That may be connected to this. WA 633 of 25, my lord. No, not yet, my lord, not yet. It is, my lord. I'll comply with that, my lord. I'll comply with it within 2 days, my lord. Yes.
Your lordship's kind of.
My lord, let them not precipitate, my lord, as your lordship said.
I don't think that they are not filing any contempt.
My lord, all that I'm saying, my lord, let him only, my lord, the advocate undertake that they'll not do anything on this till the matter is heard.
They are trying to change the nature of the property.
They're trying to change the nature of the land, my lord. They've dug up the road also, my lord.
They have blocked the public road. They have dug up the public road, and Lord, all drainage, everything has been removed. I have photographs produced.
My lord, to show
But what
that-
is happening is it's there next to the school. Water is gushing inside. Students are not able to go inside. Buses next to it. Your lordship can see in the next pages, Lord. There, Lord, they are not able to. They are not letting the students go inside the school. The civic community side. This.
My lord, any date after 22nd, my lord, there's a difficulty because 22nd.
These things we can't. Either we will give you whatever date you want. Give a statement saying that they will not take any risk. But the activity is going on. They have an issue.
Yes,
my lord. May pass it over for 5 minutes. Yes. For 5 minutes, I'll take it.
Yes, take it.
Please.
Serial number 83.
And for appellant, my lord, this in matter. Notice has been issued. Date may be fixed, my lord. Date may be fixed.
68.
Date, my lord.
84.
For the petitioners in 84 minutes. On the previous occasion, notice was already issued to the government minutes. All the respondents are government authorities.
Seven, eight,
Grateful.
85.
Appear for respondent number 5. This appear for respondent number 5. Matters has appeared on several occasions. There is no interim order in favor of the appellant. Still, my lord, the door number which is to be given to the small school, which was completed in the year 2022, is not issued by the Panchayat Development Officer. A request is made at least to give door number, because such a small school losing a grant of about more than 15 lakhs if it is not done within a particular time. Now the respondent number 5 says if it is not a school is not starting within 20 days, then they will lose that grant also. And what is challenged in the writ petition by way of public interest litigation is they are saying that the sale deed which is executed in favor of the school to be set aside. A sale deed is questioned in the writ petition, public interest litigation. Let the writ petition be heard. But there is the respondent number 5 has no impediment to issue door number to the completed building. That's only the request for the present matter. He has nothing to do with it. If a direction is issued to the PDO to consider the representation to give the door number.
My lords, I am applying for respondent number 3 via Panchayat, my lords. There is another writ petition pending with regarding encroachment of building, my lords. There is a disputes disputes between respondent number 5 and the adjacent landowner regarding the encroachment of the land, and one Mr. Vijay Pujari has also filed a writ petitions in WP number 3262 of 2022, my lords.
That is this petition, my lord. 3262 is this petition.
My lords, there is another writ petition, sir.
Illa. No. No, and the Panchayat has not objected to give the door number, my lord.
No, and we ourselves has to issue the door number, sir, but the petitions pending with the international. My lord says tomorrow may be had, my lord. Date may be.
ಏನು ಹೇಳ್ತೀರಿ ಏನೇನೋ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. In the orders list, may I request my
8-7.
orders list? Tomorrow in the orders list? Difficult. Please.
8-7. Pastor matters, serial number 4.
Yes, Mr. Kumar. Not here when your lordship, the matter reached, my lords. I think, my lord, your lordship is saying that it should go to the commercial court. You have to go there. I checked up with the office, my lords. They gave the interpretation was in 37(2). They issued the court as the high court, my lords. No, that's the reason. I completely, this is your lordship, so this thing is correct, my lord, not telling. But there is disconfusion in the office based on that, my lord. If the law is properly interpreted, not that this confusion will not be there.
Forget it now, you want to withdraw it, go there.
I will go to the commercial court, my lord. 1 week time will be given, my lord. Return of the files.
All the appeals?
All the appeals, my lord.
All.
I think all the appeals will go.
I don't think, you have to say so.
Then it could be taken tomorrow.
No. How many times we have been?
I got it, my lord. Now, what has happened is, my lord, your lordship kindly take to page section 37. No, 37, my lords. No, the office is 37(2). The appeal is under. Pardon?
Who has informed you?
Yes, yesterday in the registry I checked up, my lords.
You will listen to the registry or here?
How they interpret, my lord? An appeal shall lie to the court from the order of the tribunal. Court. Yes, my lord. Then I read the section 2A even. Then that's what my lord. That is the reason. Then if it's in section 17, my lords, then it may have to go to the.
So you will show the registry person, see, this is the interpretation.
What, my lord?
You show to the registry person.
I'll definitely show it, my lord.
Just say that, Mr. Gunjar, we are recording your statement, you want to withdraw it and approach the trial court within 1 week.
1 week, my lords, and return the files by day after tomorrow, my lords.
We direct the registry to return any of the original documents.
Pardon, my lord?
It is.
The court will direct the registry to return any of the original documents.
Just tell him also certified copy.
No. Please, my lord, what has happened? Certified copy is filed in one matter. Then in all matter, I filed the dispensation application.
So wherever there is a certified copy, that will be returned to you, replaced by a photocopy.
No, I will have to file 8 appeals, my lord.
Right? Rest you have sought dispensation. You have filed certified only in one.
Yes, in one. And in others, my lord, if the lordship would dispense with the production of the originals, my lord, because I'll come on 117, my lord, will barred by limitation.
Yes, that Mr.
117 will come into play, my lord, so I'll be barred by limitation. That's the difficulty.
You will get the benefit.
Please, my lord.
Mr. Gunjar states that as these appeals are not maintainable in this court, we shall withdraw all the appeals and approach the commercial court. Right?
Commercial court, my lord.
Commercial court.
Bangalore.
Bangalore, in accordance with law. He seeks the return of the certified copies of the documents filed along with these appeals. The registry shall return the certified copies of those documents which have been filed by replacing the same with the photocopy. Okay. It goes without saying that the appellant shall be entitled to the benefit of section 14 of the Limitation Act.
Please, ma'am.
For the period during which he was pursuing this appeals in this court. That's fine.
Please, my lord.
Dismiss as withdrawn.
The appeal is filed by Monday, my lords.
Within, just say that.
Within 1 week, your lordship.
By on or before Monday. You must appear before the.
Please, my lord, at least till Monday or Tuesday, I'll file it, my lord. Because 8 appeals, I had to reprint everything. It's time-consuming job for me.
We are giving you time till Monday.
Monday, my lords.
For collecting the certified copies. Just tell me.
By Monday, you'll have to appear before the registrar and collect the certified copies.
Yeah.
And then later 1 week time has been given by the court.
From then, I got 1 week time, my lords.
Copies.
The copy will get received on Monday.
We will also make clear that the 1 week shall start running from Monday when the appellant, the counsel for the appellant is given the certified copies of the documents filed along with.
Please, my lord.
Next.
Much obliged.
80. 82.
Lord, appear for the appellant.
Yeah, Mr. Chalan, your documents.
Please.
What is this, which number?
82.
82, man. Which your lordship just a while.
We'll take the undertaking not to change the nature of the property until next date of the hearing. Yes. Ravi Shankar.
He also on instruction states is an extent of area. The nature of the property in question shall not be changed. That's fine.
Yes, my lord, because we have not been doing anything and possession has always been with us.
But it indicate other way to do it.
Yes, ma'am.
You don't want to do anything.
Yes, ma'am. I just wanted to clarify that, ma'am. Sorry.
So we have to take on instructions.
Yes, ma'am. Any after 22nd, ma'am.
Whatever date you want.
Yes. Then we have no objection for his convenience.
Would not have now.
Yes.
Okay, thank you.
Obliged.
Obliged.
Serial number 75 has been mentioned with an interim order not to change the serial number 7. Thank you.